This is the Thursday, March 12th, 2015 meeting of the Zoning Board of Examiners and Appeals. Would you call the roll, please?
Mr. Vig?
Here.
Mr. Cars?
Here.
Mr. Ron?
Here.
Ms. Eicher?
Here.
Mr. Hart?
Here.
Ms. Dole?
Here.
Ms. McKay has been excused. Thank you.
Thank you. Next item on our agenda are the minutes. We have the minutes from the December 11th, 2014 meeting and the January 8th, 2015 meeting. Has everyone had a chance to review the minutes? Does anyone have any comments? And if not, I'd accept a motion to approve the minutes. Mr. Vig, you've indicated that you'd make that motion.
That's correct.
Thank you, Mr. Vig. Ms. Eicher, you've seconded.
I do.
Thank you. Is there any discussion? If not, please vote. Thank you. The minutes are approved. That brings us to our special order of business. We have two items on our item C, special order of business disclosures and annual elections. Prior to getting to item 2, annual election of officers, I would entertain a motion to reorder the agenda to move the elections to after agenda item H, public hearings. Mr. Ron.
So moved.
Thank you. And Ms. Dole, you've seconded?
Yes.
Thank you. Is there any objection? Seeing none, motion passes. The agenda's been reordered. Brings us to agenda item C1, disclosures. Are there any disclosures this evening? Yes, Mr. Ron.
Mr. Chair, I was not present at the board meeting on January 8th, 2015, and therefore will be abstaining from the vote if one does occur on consent agenda item D1A, resolution 2015-001.
Thank you, Mr. Ron. Any other disclosures? Thank you. That brings us to consent agenda item D1A. We have one resolution on the consent agenda, resolution for approval for resolution 2015-001. Do we have any, actually I would accept the motion to approve the consent agenda. Excuse me, this is for a consent agenda item for a resolution on a case that was heard in December of 2014. It's not for this evening. And in the future, if anyone does wish to speak, they need to be recognized by the chair, come forward and speak into the microphone. Resolution for approval for resolution 2015-001. Mr. Vig, you've indicated move to approve.
Move to approve the consent agenda.
And Ms. Eicher seconded that?
I do.
Thank you. Is there anyone wishing to pull that item off the consent agenda? Seeing none, can we have a vote, please? That motion passes by a vote of 5-0 with one abstention. Moving on our agenda, there are no appearance requests or unfinished business. Brings us to our regular agenda. And this evening we have two cases on the regular agenda. The first case is a variance hearing, and it is case 2014-0201. The second case is an appeal hearing, and it's case 2015-002. For anyone that wishes, there's copies of the agenda that are in the foyer on the way into the chambers, if you so wish to look at the agenda. There are also staff packets as well that are out there for those that are interested. What I will do before we get to our first variance hearing is read the order of business for variance hearings, and then the second case is an appeal hearing, and at that time I will go through, prior to hearing the appeal, I will go through the order of business for appeal hearings. So our first case is 2014-0201, the variance hearing. What I'd like to do again is read the order of business. The chair shall introduce the variance and explain the procedure to be followed. The variance case number and the name of the applicant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The board shall hear a brief staff presentation outlining the variance, not to exceed 10 minutes. On conclusion of the staff presentation, the board members and the applicant may then direct questions to the staff through the chair. The applicant shall give his or her presentation, not to exceed 10 minutes. Throughout the proceedings, the burden of proof rests upon the applicant, who must convince the board by a preponderance of the evidence that the variance should be granted. On conclusion of the applicant's presentation, the board members and the staff may then direct questions to the applicant through the chair. The hearing shall then be open for public testimony. Each person has 3 minutes. Representatives of groups have 5 minutes. All persons who testify may be questioned by the board, staff, or the applicant. On conclusion of the public testimony, the staff, followed by the applicant, shall have the right of rebuttal. The board shall proceed to develop oral findings and conclusions with regard to the variance and disposition of the variance. The staff shall reduce the oral findings and conclusions to writing for subsequent adoption by the board at a later meeting. The matter then rests with the board, and the chair asks for a positive motion from the board. For both our for both cases this evening, in order for a variance to be granted or appeal to be granted, a majority of the fully constituted board is required. The fully constituted board consists of 9 members, so while there are, sorry, I had to do the math, 6 members here, it still requires 5 members to vote in favor. With that, that brings us to our first case this evening. The petition, or case number 2014-0201. The petitioner is Lawrence R. Stone Properties. Is the petitioner or the petitioner's representative here this evening? Yes. They've indicated they're present. Could staff provide us with a sufficiency of notice, please?
Thank you, Mr. Chair. On January 14th of this year, 33 public notices were mailed. 2 comments opposed to the request were received after the report was written and printed. However, the comments were included in the packet that went to the board members for this case. This is a request for variance from AMC 2140-200G2 to allow a 36-foot by 36-foot elevated second-story addition to an existing 2-story structure to encroach 3 feet into the west side yard setback on Lot 6, Block 1, King Subdivision. The petition site contains 40,050 square feet. It's located on the north side of West 92nd Avenue and west of C Street. The lot is rectangular in shape, measuring 265 by 150 feet, and the majority of the lot is level. The southern portion of Lot 6 is bisected by a 6-foot drop in elevation from West 92nd Avenue. However, trees have been planted along the embankment of the slope. There are no wetlands or streams that affect this property either. With the exception of remaining natural vegetation along the west side of the two-story building, the lot has been cleared of vegetation. It is served by electric, gas, and public water. In reviewing the standards for that apply to a variance request, standards 1, 2, and 3 do not appear to have been met. There are no physical characteristics of the lot that would have prevented the addition to be constructed in a conforming manner. The I-1 district allows construction to the lot line, or if a side yard is provided, it must be 5 feet in width. So the 3-foot encroachment is into a required 5-foot side yard setback. Standards 4, 5, 6, and 7 do appear to have been met. Granting the variance would not adversely affect the use of the property adjoining the west boundary of the petition site. Granting the variance will not change the character of the zoning district and does not permit a use that is not otherwise allowed in the I-1 district. The variance granted would not adversely affect the health, safety, and welfare of the people of the municipality. And the stairway to the second level is located within the portion of the structure that encroaches into the west side yard setback. The requested variance is the minimum necessary to allow continued access to the elevated second level without undertaking extensive remodeling and relocation of the stairway entrance. The department, however, does recommend denial of the variance as standards 1, 2, and 3 do not appear to have been met. However, if at the conclusion of the public hearing the board finds that all standards have been met, the following conditions on page 6 of the packet are offered for the board's consideration. Thank you, Mr. Chair.
Thank you, Ms. O'Brien. Are there questions of staff by the board members? Yes, Mr. Ron.
Thank you, through the chair. Ms. O'Brien, for the record, can you enlighten us with respect to a comment made on page 3 of the staff packet, first paragraph of the site description and proposal, and perhaps expand upon it? The I-1 district regulations do not require a side or rear setback. However, if a side yard is provided, it must be 5 feet in width. So I'm reading that fairly literally, in that if there is no side yard provided, it's not bound by any setback requirements, and no side yard is in fact required. But because one has been provided, there is a setback associated with it. Is that?
Through the chair, in the I-1 district, one is allowed to construct to the lot line. And so they are allowed to construct to the lot line. But if there is a side yard provided, then it must be 5 feet in width. So this does encroach into a 5-foot side yard because the structure is not built to the property line. It's an either or. You either build to the property line or you provide a 5-foot side yard setback. And in this case, they did not provide a 5-yard, they did not build to the property line. They did construct with a 3-foot side yard setback, which does not satisfy the requirement for a 5-foot side yard setback.
So if you can comment then with respect to this case, is it the property developer's decision then as to whether or not to build to the property line versus providing a minimum 5-foot yard setback?
Through the chair, that is correct. It's the developer of the property. They either develop to the property line, or if they do not, then they provide a 5-foot side yard setback. It can't be a 2 or a 3 or any variation of 5. It must be 5.
Okay. One more question, and then I'll get off this topic or let somebody else take over. What's the reason for 5 feet in the I-1 district? I'm trying to resolve the conflict between building at the property line or 5 feet, and if you can provide additional reasoning behind what the 5 feet stands for, that might be beneficial.
You could, the 5 foot is just a standard that has been established in the I-1 district. It's the property next door. If they had a building and if they built to the lot line, they would, and if both that would be permissible. If you build to the lot line on two lots that are adjoining, then there must be a fire protection wall in each of those structures. So the 5 foot is to provide some separation for fire protection.
Thank you.
Mr. Vig.
Thank you. Ms. O'Brien, I'm going to follow on Mr. Ron's questions and see if I can understand it better. So the 50-foot by 72-foot shop building that's north of this structure in question appears to be built to the property line there. That does not extinguish the existence of the 5-foot setback on the other structure on the lot? I'm looking at the as-built survey prepared by Del Norte Survey.
Sorry, Mr. Chair, Mr. Vig, could you repeat your question?
Well, I'm looking at the as-built survey, and there appears to be a building that's separate from the structure that we're here to review tonight. That structure to the north of that structure in question is built to the property line on the west side. So, in effect, there's no side yard setback there. Does that not extinguish the setback on the remainder of that west lot line?
Mr. Chair, Mr. Vig, no, it does not. It extinguishes the building is built to the property boundary. The side yard setback still remains along the west property boundary. So the elevated second-story building could have been built to the property boundary. There would be no encroachment because that is allowed by the I-1 district. However, that building was not built to the property boundary, so therefore it was required to provide a 5-foot side yard setback.
And just hypothetically, would a building owner have the ability to add on to that elevated second floor a structure to extend to the property line and be in conformance?
Yes, that's correct, but it would be for the, see, there's parking underneath this second story. So there's only a second story on pilings. And so they could expand the structure to extend to the side property line, the west property boundary, and that would be in a similar situation as the 50 by 72 foot shop building concrete floor. It would be that. It would be equivalent to that building.
Okay. And then just for clarification, in the second paragraph, it refers to this property being west of C Street. Is it not east of C Street? I want to make sure I understand where it is.
Oh, wrong packet. Yes. Mr. Chair, Mr. Vig, I stand corrected. It is east of C Street.
Okay. Thank you.
Ms. Dole.
Thank you. Through the chair, my questions also related to that topic and have been somewhat answered. I was curious if there was a definition section of the code that defined side yard setbacks, or if there was something you could point to for a definition. Just because of the section we've been talking about that says if a side yard is provided, it has to be 5 feet in this zone.
Mr. Chair, Ms. Dole, yard setbacks are defined. However, the depth or the dimension of side yard setbacks, rear yard setbacks, and front yard setbacks varies throughout the zoning districts. So in the I-1, you're allowed to build to the lot line, but if you don't build to the lot line, you have to provide a 5-foot side yard setback.
Okay. Thank you. And I guess I was a little confused by one of Mr. Biggs' comments in terms of the plan. He pointed out there were 2 buildings next to each other, and it appears that the encroachment is on one of the, it applies to one of the buildings, but not to the building to the north. Is that correct? Is my understanding correct, or am I confused?
Through the chair, Ms. Dole, there is no encroachment in the northernmost building.
On the west side?
There is no encroachment because they are allowed to build to the lot line. So there is no encroachment. Because this addition that was built at a later date than the original structure, the 2-story building, it either had to provide the 5-foot side yard setback or build to the lot line.
So does the side yard setback apply to, when there are multiple buildings on one lot, do you distinguish, or, and one building is all the way to the property line, and the other one is not, then that's viewed as creating a side yard setback for one building, although not for the whole lot, on the same side of the lot?
Mr. Chair, Ms. Dole, the 5-foot side yard setback exists along the entirety of the west property boundary. But the I-1 district regulations allow a building to be constructed to the side property boundary. If it is not, then it has to provide 5 feet. If there are multiple buildings on the property, they all either have to be built to the property boundary, or they would all have to provide the 5-foot side yard setback.
Thank you. I don't have any further questions.
Thank you. Are there any other questions of staff? And again, Mr. Hart.
Was that read from regulation, or was that just a personal or not definition, but explanation?
Was that a question
Yep,
to the staff?
Staff member. Was that just a personal interpretation that you just stated, or is that something that was actually read from the regulations or code? Sorry.
What I stated was based on the regulations.
Okay. If I could ask a question, Mr. Chairman.
Yes.
So reading through this, I guess I have a different interpretation. So it says there is no side or rear setback in this specific zone where a lot, except that where a lot adjoins a residential district, a side or rear yard shall be provided equal to that required in the adjoining residential district. If a side or rear yard is provided elsewhere, it shall not be less than 5 feet in width. I guess what I interpreted from that is it's connected to a residential district, then that residential district couldn't create a 3-yard setback. It'd have to be at 5 at a minimum. So if the residential district had a 3-yard setback, not saying that there is one that does that, but that's what it would do. I guess that's how I interpreted it. And since it's not connected to a residential district, I guess I don't view that as applying. So maybe if there could be some clarification on that.
I don't know what I was saying.
Yes, could staff respond to that?
Through the chair, Mr. Hart, correct. My name's Jillian Inglis, and I'm the lead land use plan reviewer for the planning division. The code that you're referring to, the residential district may have a different setback, so they may have to provide a larger setback. But in the I-1, you either build to the property line, or you can only, if you provide any setback from that property line, it has to be at least 5 feet. You can't go 1 foot or 2 foot or 3 foot. You have to either be on that property line, which would require probably a firewall of some sort to be constructed if you're building on that property line, or you have to build right to the 5-foot setback. You can't go into that unless you're at the property line. So if one building is built to the property line, in that case, the question of the north building, that building is in compliance because it's built to the property line. But if the other building is not built to the property line, or at least 5 feet from the property line, then that building is out of compliance. So in this case, there's a 5-foot side yard setback.
Are there other questions of staff at the board? Yes, Mr. Ron.
Thank you, through the chair. Ms. O'Brien, if I could direct our attention to the survey from Del Norte. I'm looking at page 18 of the staff packet. It appears to be a topo line shown on that survey as well. I'm having trouble reading the version I have. Are those 2-foot contours?
Through the chair, Mr. Ron, they're 1-foot contours.
Thank you.
Yes, Ms. Inglis.
Through the chair, I also wanted to follow up on that previous question. If you look at the words, in the residential district, he's correct. It says none, except for that when the lot adjoins a residential district, a side yard setback shall be provided equal to that required in the adjoining residential district. So if the adjoining residential district has a 5-yard side yard setback, then the building will have to be constructed at least 5 feet from the property line. If a side or rear yard is provided elsewhere, it shall, so that's in any other situation elsewhere, it shall not be less than 5 feet in width. So you either build to the property line or you build 5 feet. I hope that clarifies.
Are there other questions of staff? Yes, Ms. Dole.
Thank you. Through the chair, I am curious with regard to the comment on Standard 7. The variance granted is the minimum variance that will make possible a reasonable use of the land, and the staff recommendation is that the standard is met because it's the minimum necessary to allow continued access to the elevated second level without undertaking extensive remodeling and relocation of the stairway entrance. My question is whether if I thought I heard I thought I heard staff say that if the variance is that the owner has the option to build out, and so if so in theory, I would think that perhaps no variance would be needed because they could continue to use the stairs and the elevated portion by building out to the zero line, to the lot line. So I guess I was wondering about the response to number 7, and whether whether it was the minimum variance to make possible a reasonable use of the land, if they could continue to use it by simply adding on.
Through the chair, the applicant has requested a variance, so to use the building as it exists. So as it exists, this variance is the minimum possible variance necessary to continue to use the building as it exists. The response that they could build to the property boundary and bring it into conformity was raised in this public hearing. The applicant did not pose that solution. They chose to request a variance. So in response to that standard, it is the minimum variance necessary to continue using the building as it is. However, the alternative is to build to the side property boundary. There would then not be an encroachment into the 5-foot side yard setback because they are allowed to build that second-story addition to the property line.
Thank you.
Thank you. Are there any other questions of staff? And I do have one, and I'm going to, I think, paraphrase Mr. Ron's question and your answer, Ms. O'Brien, but just to make sure I understand, they can build to the property line, and then the intent would be if the adjacent property were to build to the property line, there's no setback between the two structures. There's no fire safety issue. But if they were going to build to some other distance than right at the property line, it needs to be a minimum of 5 feet so that the adjacent property, if they were to do the same, would there would be 5 feet of separation. They would be either at 0 or another 5 feet or 10 feet. So the purpose of somewhere in between 0 and 5 is for fire safety?
Mr. Chair, if you had a lot, 2 I-1 lots sharing a common boundary, and both lots were developed with buildings that were constructed to the common lot boundary, there would be fire protection in terms of each building would have to provide a firewall, which is fire resistant. If this property extends to the 5-foot side yard boundary, to the property boundary, then the property on the adjacent lot, if they constructed a building, which they don't currently have because it's filled with cars, but if they were to build, they would have the option of building to the property line. They, too, would have to provide a firewall, or they would have to build their building 5 foot separated from the common property boundary.
Thank you. Are there any other questions of staff? Seeing none, could the applicant come forward, please? Could you please state and spell your name for the record?
Yes. Adam Cook, that's ADAMCOOK.
Thank you, Mr. Cook. And do we have something in our package that shows that Mr. Cook can represent the petitioner? Is there a letter of authorization in our file?
Mr. Chair, no, there isn't a letter of authorization. Mr. Cook is the petitioner's attorney.
And I do have a letter, if you'd like me to submit it.
A letter of authorization?
I have one right here, so,
You would have to submit it
Yes.
to the chair.
all right. Should I give that to you after we're done, or right now?
No. Mr. Chair,
Get
that
it
would
right
have
now.
to be now.
We need it now prior to.
Also, Mr. Chair, the microphone does need to be on the podium because we can't
Yes.
hear.
There you go. Thank you, Mr. Cook. And you will have 10 minutes for your presentation, Mr. Cook. And again, we must find that all 7 standards are met to grant a variance. So if you'll make sure you address the 7 standards in your presentation.
Certainly. And at this point, can I reserve 2 minutes of that 10 for rebuttal?
Yes, you can.
Thank you. Thank you again. My name is Adam Cook, and I do represent LB Stone Properties. They're the owner of the property and the requester of the variance. And you've just heard the basic facts. I'm going to kind of give a little detail on the history of the property because it is important before going into the 7 steps that we discussed earlier. I want to make sure that everyone has a copy of this little packet I handed out because the first page is very important. It's a photograph, an aerial photograph of the property. And if you'll take a look at that, you'll see there's a large white rectangle that represents the property lines. Of course, there's nothing official here. This is just something I drew up. And then inside that larger box is a smaller one, and that's the offending structure, 36 by 36 feet. And I want to give a little bit of background here. This property was originally residential, then it was zoned light industrial, and for a while it was used for light industrial purposes by a group called Rockford Corporation. In 1994, Rockford owned the property, and they owned the building, which you'll see there sort of at the bottom left of the photograph. You've got the white rectangle, then you've got the building underneath it. That building existed in 94, and Rockford decided they wanted to expand onto it and add a 2-story addition. So to the north side there, they applied to build a 25-foot by 32-foot 2-story structure to use as office space. And they submitted an application to the municipality. Municipality approved a construction permit. But then somewhere in the course of construction, Rockford decided that they wanted to change the dimensions of their new addition. So they changed it to 36 foot by 36 foot. And this expansion resulted in a change in the space between the addition and the property line. It was going to be 12 feet, but now with this change, there's only 2 feet there between the boundary and the west side of the building. And if you turn to the second page of the packet, you'll see a drawing. This was something that Rockford submitted to the city halfway through their project. They said, we're going to be making a change here, and we would like authorization to expand the dimensions of the building. So here's a drawing showing the new 36 by 36 building, and you'll see a stamp there where the city has written approved, October 31st, 1994. So the city approved the expansion, the building went in, and as a result, it was only 2 feet from the boundary. Now, in 1994, the zoning requirement for a 5-foot setback was in place, and yet the building got built. And not only did it get built, but the city went in there after approving the dimensions. They reviewed the construction, and they issued a certificate of occupancy. They had absolutely no problem with the building. Once again, despite the 5-foot setback requirement, and despite the fact that they were only 2 feet from the boundary. Well, 16 years later, LB Stone bought the property, and LB Stone uses this property as storage and sale of metal fasteners and other industrial products. And LB Stone renovated a part of the property up there at the top left corner, that shop we were talking about earlier. And the city said, that's acceptable, we accept your renovations, but we're not going to give you a certificate of occupancy because you've got a problem. And the problem is that your 36-foot by 36-foot office space is violating our 5-foot setback requirement. And once again, this is a 2-story structure. It's used as office space, and it's very important to LB Stone. Excuse me. So they weren't going to grant the certificate of occupancy, which means we would like a variance. And of course, the city recommended no variance. So we're going to go very quickly through the 7 elements as part of our request. You know, the first one, there are exceptional, extraordinary physical circumstances of the subject property. There's really 2 things I want to hit on here. The first one is that the physical circumstances are that the owner inherited the building. The owner did not build in violation of the code. The owner relied on both the previous property owner and the city itself when the city approved this structure. That's the first physical circumstance of note. The second one is the purpose of the zoning code. We brought this up earlier. The setback is there in the case of a fire or earthquake. You don't want neighboring structures adversely affected. The building falls down, it takes another one with it. The building burns down, it takes another one with it. So you have a 5-foot setback there on either side, which means that the buildings aren't affecting each other. Now, once again, if you look at the photograph, you'll see that to the west of the property, there are no structures. That's being used as a storage lot, primarily for abandoned vehicles and other odds and ends. That lot's owned by Mr. Sid Hancock. You'll see on the 3rd page of the packet that Mr. Hancock has said he has no problem with a grant of variance. Go for it. He's not planning on building on the property, which means that there's no risk of damage or collapse or fire to another building as a result of violation of the 5-foot setback requirement. So that's the second physical characteristic that's significant here. You've got the fact that they inherited something that the city approved, and then you've got the fact that there's no risk that the safety issue, which is being addressed by this provision, is going to be triggered. Okay, the second one, physical circumstances such that the strict application would create an exceptional or undue hardship. Yes. It is very clear that the only way that this violation can be addressed is for LB Stone to demolish its building or, as was discussed earlier, theoretically build out to the property line. Demolition of a 2-story office structure, which is in use and vital to the company, is not only going to cost thousands of dollars, they will have to rebuild it with the proper setback, and what's more, it's going to interrupt their business and perhaps even destroy it. What about building out to the property line? You might be asking yourselves, well, you've only got 2 feet to work with, so you're not going to be creating a usable space. You're definitely going to be creating a firewall. You're definitely going to be interrupting other activities in the building, and it's definitely going to cost a tremendous amount of money. And there's also the fact that you have to enter the other property in order to build on your own property, and what you get is a real ordeal for the landowner. That's the undue hardship that satisfies the second element of the variance request, depriving the applicant of the rights commonly enjoyed by other property owners who don't have to demolish or reconfigure their buildings on account of a safety hazard that doesn't exist. The third and final point, which the city says hasn't been met, is that the hardship is not self-imposed. Special conditions and circumstances do not result from the actions of the applicant, and such conditions and circumstances do not merely constitute inconvenience. Frankly, I'm a little surprised that the city said this one's not met, because this is not a self-imposed hardship. This building was built in '94. 16 years later, LB Stone moves in, and 20 years later, the city says, well, we approved it, and now we're disapproving it. Demolish. That creates a hardship, and that's unreasonable. It's not a mere inconvenience. This is a serious inconvenience. And that's why that third prong is satisfied, and that's why all 7 prongs are satisfied. Are we done?
Well, your time is up. You have 2 minutes of rebuttal if you'd like to use any of that rebuttal time to finish.
I think I got most of my points in. Thank you.
Thank you, Mr. Cook. Are there any questions of Mr. Cook by the board? Yes, Mr. Ron.
Thank you, through the chair. Mr. Cook, thank you for providing this aerial photo. Can you speak to activities that may occur in the central part of what I believe are lots 6 and 7? We see it appears fixed structures there, but there appears to be some storage. Is there movement of equipment in that area? What is that part of the lot used for?
Now here we're talking about the very center of the property. This is used for, like I said, metal fasteners and other objects which are being stored on shelving units. Customers are coming in and reviewing the material and then taking it out to use for industrial purposes.
Given the way that those fasteners are stored, is there advantage for that storage to occur on a flat and level part of the lot?
Yes, these shelving units do require a level, hard, dry surface because they occupy thousands upon thousands of pounds of metal equipment.
So noting that in the staff packet there is some documentation of grade change on the southwest corner of the lot, can it be said that you wouldn't want to store those fasteners on the southwest corner of the lot?
That's correct. Any sort of change of grade is potentially hazardous for these shelving units. So relocating them does come with a risk to the extent that there's a change in topology.
One more question, if I can, Mr. Chair. Mr. Cook, can you speak to the drainage on the property? We have some comments from the public that may come to light during public testimony, but if not, I'd like to hear your comments about how drainage is managed on this lot.
Certainly. Drainage is strictly a snowmelt problem as far as we know. And there are two drainage areas. There's the south boundary there along 92nd Avenue, and there is some runoff from the property onto the property boundary at the north. And that, of course, is runoff onto another property, which is problematic, and which LB Stone has been working to address with the city. They made changes just a few months ago to the ponds and to the runoff. And with the spring breakup, even though there hasn't been that much snow, we're fully expecting that the drainage problem has been resolved. And once again, the city has said that they hope the same after reviewing that construction work.
Thank you.
Thank you. Ms. Eicher.
Thank you. Thank you, through the chair. Mr. Cook, can you speak to standards 1 and 2 with regards to the physical characteristics of the lot, and include any remarks that you have? Those are the standards I'm immediately interested in, and I heard what you had to say about the structure and how it impacts standards 1 and 2, but it would help me if you could talk about the physical characteristics of the lot.
Well, the physical characters of the lot are primarily the extent to which it is occupied is built upon both there and on the neighboring structure. Once again, the purpose of the variance is to take a look at the safety issue which is being addressed by the setback requirement. The physical characteristics are such that a fire or earthquake are not necessarily, in fact, not at all, going to jeopardize structures abutting the nearby property because there are no structures there. That's the primary important physical characteristic. And of course, Mr. Round just made a great point about the topology. These shelving units are essential to the business. If the physical characteristic includes a 1 foot change in grade, 2 foot change in grade, it might be impossible to store our products there the way that we have to run as a business.
Are you familiar with the case City and Borough Juneau v. Thibodeau?
Not right off the top of my head.
I think I'll wait to see what other comments my fellow
I
board
can,
members have.
I can follow up with a supplemental later on after taking a look at that.
No, it's real briefly, if you have any comments, it's a case that speaks to meeting standards 1 and 2, and in consideration of those standards, it only looks to the physical characteristics of the lot itself without improvements. And that's something that this board has been struggling with in requesting these variances, because I think you could see a circumstance such that a physical characteristic, if you are looking at the subject matter that's imposing the problem itself, necessitates a variance. It's kind of a tautological reasoning if you're looking at the building that needs the encroachment as the reason why there's something special with the lot. So the Thibodeau case is something that we struggle with in looking at either an odd shape, really steep slope, things like that. So that's what I was
Sure.
wondering if you had any thoughts on that case's application to what we have before us.
The only thing I could add to that is, this is actually a little bit similar to the property owner who discovers his house is sinking and finds out that there is a creek bed underneath the property that he had no knowledge of. Now, granted, that's a physical characteristic phenomenon, whereas here you have a physical characteristic being a building with a completely unforeseen condition being its placement, the fact that it was approved, everything that was done to rely on it. Granted, that's more philosophical, but it's still the property owner discovering a condition on his property that he had absolutely no reason to know of.
Thank you.
Yeah.
Ms. Dole.
Thank you. That was a useful discussion. I just wanted to ask about another
Ms.
matter.
Dole, could you speak more directly into the microphone? Thanks.
Certainly, sorry. I just wanted to ask about something that I saw in the non-conforming status determination on page 27 of our packet. It looked like that they addressed both the side yard setback and also a landscaping issue, but the landscaping issue is not before us in this variance request. And following on, I guess, with the discussion relating to physical aspects, I just wanted to know if or how that the plans were to deal with that. It says, therefore, the landscaping on the subject property is required to be brought into compliance with the design standards for the visual enhancement, parking lot perimeter landscaping, and cites a few sections. I guess I just wanted a little detail on that.
Certainly. I'll tell you what I know. The southern portion of the property contained detention ponds for water runoff. That was part of the problem. It's like I mentioned earlier, there was water runoff into both 92nd Avenue and the property to the north. Those landscape changes were engineered changes to the detention ponds and to the direction of the runoff to prevent it from flooding the street or running off into neighboring properties. Those all took place at the south of the property and the north boundary of the property. If you look at the building that we're talking about today, it's on the sort of west center of the property, which means it really wasn't in any way impacted by the landscaping. The work that had to be done was not done anywhere on or near the structures. Does that answer your question?
Yes, it does. Thank you.
Okay.
Are there any other questions of the petitioner? I do have one question, Mr. Cook. You had referenced a letter from the adjacent property owner, and I think you said on page 3 of the packet.
Yes, it is.
I don't see that on my page. Oh, on what was handed to us this evening.
I have a spare also. The gentleman's name is Sid Hancock.
Thank you. And that was handed to us this evening. Okay, thank you.
Yes.
Thank you. Were there other questions of the petitioner? Yes, Ms. O'Brien?
Mr. Chair, I do have a question of the petitioner's representative. It's on page 17, which is the document referred to that the city approved the building plans. However, I cannot determine where the lot line is. There's no north arrow on this particular document, and I'm not quite sure what was actually approved because it's not shown in relation to the property boundary. So I'm not sure that the municipality actually issued a building permit in error when there was no lot lines shown. And this is basically a footing and foundation plan And so I don't know if there's any information that can be provided on this document, which the applicant is relying on to say that the municipality issued something in error.
So was that, I'm assuming that was a question of the applicant then, Ms. O'Brien?
Mr. Chair, it was through you to the applicant, yes.
Thank you.
And I believe the question is what our response would be to that assertion. This change in the footing and foundation plan necessitates expansion towards the property line. And while I agree that looking at it right here, I do not see a property line depicted, the city, of course, had access to all the other platting and drawing, which presumably they consult when they're giving permits and change orders. And therefore, by incorporation of those documents, was fully aware that the expansion would encroach on that 5-foot line. The second point I would make in response is that the city actually approved the building twice. The second time, when they came out and reviewed it and issued a certificate of occupancy, I think that a responsible municipality inspector would see that there was a 2-foot gap between the property line, or see that it was a smaller gap than was planned, would see whatever it is that would trigger concern about this. They didn't see it. They approved it and issued the certificate.
Thank you, Mr. Cook. Does staff have a follow-up question? Planning staff one?
Mr. Chair, this is the document upon which the argument is based. This was in '94. I have no knowledge that the whoever approved this was fully aware of the addition in relation to the lot line. There's no, I can't verify that, yes, the city was at fault. They knew exactly what they were doing. The other point is that when you're doing inspections for, say, structural inspections, it's a matter of inspecting the structure itself. There is vegetation along part of that lot line, and that would be hard to determine without a survey. There simply is no evidence where the property line is on this document. And that's what was presented to the zoning board. So I just, I question what is the approval for. It says footing and foundation, but it's not an as-built survey.
And Ms. O'Brien, is that a rhetorical question, or are you asking, again, this is a time for you to ask questions of the petitioner. There'll be rebuttal after for both staff and the petitioner. So if there's a question there, could you make the question?
I guess the applicant said that he doesn't know where the lot line is, so I'll have to close my comment.
Are there other questions of the applicant? Yes, Mr. Ron.
Through the chair, Mr. Cook, do you have any historical knowledge of this parcel? When I look at page 9 of the staff packet, I don't think it's unreasonable to assume that there are some wetlands to the north. General knowledge of this area is that there are some wetland complexes, and there's been some development amongst that series of wetland complexes in the area. Do you have any knowledge as to whether or not there were wetlands on this parcel prior to development?
I don't. I know that this parcel and the adjoining ones were residential prior to 1972. After that, they were zoned light industrial, and they have been used in that capacity since then. They are all, well, a lot of them are pretty well developed, which suggests that if they were wetlands, some sort of permission was involved there.
Thank you.
Are there any other questions of the applicant? Seeing none, does staff have any further questions?
No, thank you, Mr. Chair.
If not, Mr. Cook, if you'd have a seat, we will open the hearing up for public testimony.
Thank you, Mr. Chair.
Is there anyone from the public wishing to testify? Would you please come forward? And would you state and spell your name for the record?
Derek J. Hartman, DEREK HARTMAN.
Thank you, Mr. Hartman. And you have 3 minutes for your presentation, or testimony, I'm sorry.
Perfect. I'm here speaking on behalf of the owners, to which is my father, of the property to the north and the property to the east of the building and property that's in question. We did develop property to the north this summer. We built a building, put in 91st Avenue, built another building to the northeast of the property in question. And over the course of the last, we bought the property in 2000 or 2001, I'd say. The property in question in the building, the topography, if you will, of the whole thing has always constantly had runoff to the north and to the east onto our property that has caused us severe water issues you could imagine during breakup, things being frozen to the ground during the freeze and the thaw in the spring. That's been a major issue. In the last 6 months or about in the summer, they did put in a storm drain system that probably takes care of about 40 to 50% of the runoff. If you were there and able to see the property, you could see that there's definitely water from rain and not only breakup that drains onto our property, and it's just caused major headaches throughout. Another issue that we've had with the topography of this property in the construction of the, I guess, I don't know which lot that is. It's right on the corner due north of the lot that the building in question is on. We had to excavate, I believe, over 40 feet or 30 feet worth of trash, rubber tires, metal, fencing, things that the previous owners, I'm sure, had buried in developing this lot. It cost us $umpteen-thousand to take care of all of this stuff. Major headache. Their fences, over the course of the last 4 or 5 years, we've been requesting that the fences that they had put up or bought the property with, they're all on our property as well, running north and south as well as east and west. And so there's just a number of different things, and even myself personally with the water runoff, I've spent many, many hours before the last year, in the last 8, personally with our pumps, our fuel, my time trying to deal with all their water runoff and pumping it actually further onto our property, which caused us even more of a headache, and excavating all the peat because this is a wetland. It was Class C wetland. Last thing I have to say is I'm just against any variance of, somebody being able to not uphold the law, and, that's all I guess I have to say.
Thank you, Mr. Hartman. Are there any questions? Just 1 minute. Let's see if there's any questions of any of the board members. Mr. Hartman? Thank you.
Thank you.
Is there anyone else from the public wishing to testify? Anyone at all? Seeing and hearing no one, the public hearing is closed. Does staff have any rebuttal?
Mr. Chair, I just wanted to clarify. The encroaching structure is not a 2-story structure. It's a 2nd-story addition. There is parking underneath that 2nd-story addition, so it's not a 2-story addition to the building. Thank you.
Thank you. Does anyone have any questions of staff on the rebuttal? If not, would the applicant like to come forward, and you have reserved 2 minutes of rebuttal time?
Thanks, yes, and I can be exceedingly brief. First, I just want to address this concern about, well, how do we know what the municipality knew when they knew it? And although there is vegetation along the line there, I encourage the board to take a look at that photograph. I mean, there is objects, abandoned vehicles, things right up to the property line and 2 feet away from the building. This should have been evident to anyone who was going out to visit the property and to issue a certificate of occupancy. And also, anyone who was responsible for the permitting and change order should have been aware of the position of both the building and the boundary. It's just common sense. The second thing and the final thing is that, the purpose of the variance is it's granted when there's a balance or an imbalance between the safety consideration of the zoning requirement and the undue hardship to the property owner. There's an imbalance here. The safety consideration, fire, earthquake, tragedy striking and resulting in damage to the other property, it's not here. The other property has nothing on it. And the undue hardship is tremendous. It's either demolition of vital office space that's essential to the business, or some kind of addition and getting permission from the neighbors to build onto their property. It's an enormous hardship for a company that had nothing whatsoever to do with the construction of this building or the ensuing violation of the zoning laws. Thank you.
Thank you, Mr. Cook. Are there any questions to Mr. Cook on his rebuttal? I do have one question. We heard from one person from the public discussing the issue with the fence, while the issues that I heard raised were not with respect to the west property line. Fence on the east property line. Would you care to respond to that, or your knowledge of the location of that fence and what, if anything, is being done to resolve that?
Certainly, and you are correct. Concerns about runoff in this fence have nothing to do with this building. The fence here is on the north boundary of the property. It's a chain link fence built on the property line, so in this case satisfying the zone requirement. Mr. Hartman chose to excavate the property in preparation for building right up to the property line. They resulted in a 6-foot vertical grade, and as a result the chain link fence started to fall over into Mr. Hartman's property. This created any number of safety issues and problems with the city. The city demanded that he shore up that grade and make it so that the fence isn't falling over, the property isn't collapsing into his, and the lateral support is supported. And my understanding is that he has at least started building a retaining wall to prevent the property from collapsing. He says the fence is something like 2 inches on his property. We've had independent surveys done, and there's no indication that that fence encroaches on anyone's property by 2 inches or less.
Thank you. Are there any other questions of the petitioner? If not, thank you. With that, the matter rests with the board. Could I have a positive motion from a board member with respect to this case, please? Mr. Ron.
Thank you, Mr. Chair. It's been a few months since I've done this, so you might have to help me through it. In the case number 2014-0201, I move that the board grant a variance from AMC 21.40.200 G.2 to allow an existing structure, strike the D, to encroach into the 5-foot west side yard setback in accordance or with consideration for department recommendations 1 and 2 on page 6 of the staff packet.
Thank you, Mr. Ron. Ms. Eicher, you've indicated you would second that motion?
I do.
Thank you, Ms. Iker. Mr. Ron, would you care to speak to your motion, please?
Thank you, Mr. Chair. I'll start for the record by concurring with staff's findings on standards 4 through 7 in agreement that those standards have been met, and focus my discussion on standards 1 through 3, or findings 1 through 3. Based on the testimony elicited and provided by the petitioner's representative and discussion by the board and others, I find that standard number 1 is at least partially met. We've heard some testimony with respect to grade change, as noted by the staff in the southwest corner of the lot, and looking at the plot plan and noticing that the large flat area has been preserved within the center of the lot, maximizing its use for industrial purposes, the movement of equipment, the storage of materials. See some reflection of the effect of topography on this lot and the placement of structures therein. Following suit with that line of argument, I find that standard 2 has been met, and do concur with petitioner's representative that strict application of the code would create an exceptional or undue hardship upon the property owner. With respect to standard 3, find that it is partially met in that the hardship is not self-imposed, and the circumstances that discussed with respect to physical circumstances are not the result of the applicant in this instance. For those reasons, I intend to support the motion.
Thank you, Mr. Ron. Ms. Iker.
Thank you. I was struggling with standards 1 and 2. I had myself concluded that standards 3 through 7 were already met, but I think for the well-reasoned discussion offered by Mr. Ron, I also concur that the grade change of the lot is such that the topography and the physical circumstances necessitate finding that standards 1 and 2 are met. And I will be supporting the motion.
Thank you, Ms. Iker. Are there any other comments from other board members? Yes, Ms. Dole.
I'll start by saying that I concur with staff on standards 4 through 6. I'm struggling with standard 7 because although staff explained that the variance was the minimum necessary to allow the existing use of the two-story structure, the standard speaks to a reasonable use of the land. I think that an office is certainly a reasonable use of the land. However, I don't know that this variance is the minimum that would make possible office use on this lot. So I'm struggling a bit with that. I disagree with staff as to standard 3. I do believe that the hardship is not self-imposed. But I'm also struggling with findings 1 and 2, and at present I am not convinced by the preponderance of evidence that there exist exceptional or extraordinary physical circumstances that are not applicable to other land in the same district that affect the placement of the structure or dictate that the structure be some 3 feet into the side yard setback. And without finding number 1, then I can't find that standard 2 is met. So that's, I guess, where I'm at right now, and I'm open to further comment or discussion.
Thank you, Ms. Dole. Are there any other comments from board members? Anyone at all? Yes, Mr. Vig and Mr. Hart.
Thank you, Mr. Chairman. Yeah, this is a tough one. You know, I'm on the one hand sympathetic with the petitioner and finding themselves in possession of this situation that they did not create on their own. But on the other hand, I'm having a hard time finding the physical circumstances of the lot that make this granting this variance necessary, and so and I think staff did a good job of explaining that, which was a confusing aspect of this to me in the beginning, about the setback is it either exists or at 5 feet or it doesn't exist at all, which was it seems like it's one or the other. So I'm not sure, but probably leaning toward not supporting it at this point. But I would like to hear from fellow board members on their views on this.
Thank you, Mr. Vig. Mr. Hart.
Thank you, Mr. Chair. As it relates to the findings, I concur with Board Member Ron. I guess as it relates to the side and rear setback, personally, I still have a different interpretation than staff, and had this been a different case, and I didn't concur with Board Member Ron. I guess my personal interpretation of the side and rear setback would make me believe that this variance isn't required. I do intend to support the motion.
Thank you, Mr. Hart. I also intend to support the motion, and I do concur with the findings of Mr. Ron and Ms. Eicher and Mr. Hart. I would like to, just for the record, state I did not find the comment by the petitioner swaying in that a building permit was issued, because I think all of us board members do know, and for the public, any permit that's issued in error is not a valid permit. So I don't give that credence. However, working my way back to address Ms. Dole's comment on the minimum variance, I think anything other than this would be to have the petitioner would build their building up to the property line, or build to 5 feet. Either way, a variance wouldn't be necessary. So I do feel that this is the minimum variance. And again, one following piece of information, as the petitioner submitted, I go back to a previous board member's comments on where's the harm on this. We have from the adjacent property owner, most directly impacted by this, a letter of non-objection that they understand the existing situation. And that also, while it specifically addresses standard 4 being met, I think it weighs into my decision that 1 and 2 are met, combined with how long this structure has been in place. So for those reasons, I intend to support the motion. Is there other discussion from any of the other board members? If not, please vote. That motion passes by a vote of 5-1. I do need to read for the record. Every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. Time is it? Before we hear our next case, let's take a real brief 5-minute recess, and we'll be right back. Is everybody back, you think? We're back on the record. Our next case is 2015-0012, an appeal. I believe the appellant is here. They've indicated they are. Before we hear this case, I would like to read the order of business for appeal hearings. The order of business is slightly different than for variance hearings. The chair shall introduce the appeal and explain the procedure to be followed. The appeal case number and the name of the appellant shall be read into the record. The board shall hear and rule on any objections to the sufficiency of notice. The chair shall call upon all persons intending to testify on the appeal before the board to execute the oath specified in section 2112.430 above. At the chair's discretion, the oath may be administered to all persons as a group or to each individual before commencing testimony. The board shall hear a brief staff presentation outlining the appeal. The appellant shall give his or her presentation. Throughout the proceedings, the burden of proof rests upon the appellant, who must convince the board by a preponderance of the evidence that the appeal should be granted. On conclusion of the appellant presentation, the board members and the staff may then direct questions to the appellant through the chair. The staff shall then give its presentation. On conclusion of the staff presentation, the board members and the appellant may then direct questions to the chair. Excuse me. Well, I better just start that sentence over. On conclusion of the staff presentation, the board members and the appellant may then direct questions to the staff through the chair. The hearing shall then be open for public testimony. All persons who testify may be questioned by the staff or the appellant or the board. On conclusion of the public testimony, the staff, followed by the appellant, shall have the right of rebuttal presentation. The board shall proceed to develop oral findings and conclusions with regard to the appeal and disposition of the appeal. The staff shall reduce the oral findings and conclusions to writing before subsequent adoption by the board at a later meeting. So before we hear from staff on the sufficiency of notice, I would like to have all those who intend to enter testimony to please stand. If you intend to testify, please stand. Raise your right hand, and do you solemnly swear or affirm that the testimony that you are about to give is the truth? An affirmative reply by the witness is mandatory, so thank you. So our case this evening is 2015-0012. The petitioner is Darren Monroe. The request is an appeal in accordance with AMC 2103-050B of an administrative decision for the denial of legal non-conforming accessory use governed by AMC 2112-030. Could staff provide us with the sufficiency of notice, please?
Hi, Mr. Chair. This is Jillian Inglis with Planning. On February 11, 2015, a total of 104 public hearing notices were mailed. At the time I wrote the case, there were no comments from the public. However, you'll see a supplemental packet where you did receive some comments. I believe there was 4 comments from the public made through the computer. And we did not hear from the Huffman O'Malley Community Council, although they were notified.
Thank you. And Ms. Inglis, again, there will be a brief staff presentation followed by the appellant's presentation, again, then followed by staff's presentation. So could you give us a brief presentation outlining the appeal?
Mr. Chair, is there any objection to sufficiency of notice at this time?
Seeing none?
Okay.
No?
The case before the zoning board tonight is a different one. It's not one that you normally hear, and it's about establishing nonconforming rights. As we all know, the new Title 21 went into effect January 1, 2014. And in this case, Mr. Monroe is attempting to establish legal nonconforming rights to have commercial vehicles on an R6 zoned property. At the time we wrote the letter in January, and we still feel that there was not sufficient evidence to show or demonstrate or establish legal nonconforming rights to have commercial vehicles on the property. I also want to outline some information in the packet in case you didn't see it. There's 2 aerial photographs on page 10 and 80 of the packet. They're not there to establish that there's any vehicles or anything. We put them in there just so you can see the layout of the land and the different properties. We also have a letter from the municipal attorney on page 8. The petitioner's appeal packet starts on page 13, and there's a number of affidavits on page 15. In addition, you may hear some information about the Geist versus Municipality of Anchorage case. That starts on page 42, along with the nonconforming determination, and it starts on page 65. There were also 2 code enforcement complaints, and the case notes are located on page 71. I'm finished with my brief presentation.
Thank you, Ms. Inglis. Could the appellant come forward, please? Could you state and spell your name for the record, please?
My name is David Clark, D-A-V-I-D C-L-A-R-K. And I do have a point of clarification, if I could, Mr. Chairman.
Okay, Mr. Clark, and I didn't note that you made the oath.
I'm an attorney. I represent the petitioner, Darren Monroe, who was present in the courtroom or in the hearing room today.
Okay.
I mean, I'd be glad to swear under oath, but what I intend to do is summarize the evidence that's going to be presented by the witnesses who are going to testify under oath, and point out to the board why it is that this appeal should be granted.
Okay, and Mr. Clark, I'm not an attorney, so I'm just a simple engineer. But so you're a sworn officer of the court, is that?
That is correct. I'm a licensed lawyer to practice law in the state of Alaska.
Okay, thank you, Mr. Clark. So with that in mind, you had a point of clarification?
Yes, as I said, my client, Mr. Monroe, is here today, and I didn't know whether to split my time before the board with Mr. Monroe's testimony and my argument, or whether the board would allow him to testify in a 3-minute time period afterwards. I just was confused on that issue.
Yes. Ms. Inglis?
Mr. Chair, I think that if Mr. Clark is representing his client, he should have the 10 minutes allotted, and that Mr. Monroe can stand up and speak as a member of the community with the 3 minutes.
Okay.
That'd be adequate. I don't think I'm going to take 10 minutes. I'd like to allot a little bit of time for rebuttal if that's necessary. 2 minutes would be fine.
Okay. Thank you, Mr. Clark. You can proceed with your presentation.
Yes, the sole question before this board is whether or not Darren Monroe used the property in question to store commercial vehicles prior to January 1, 2014. Mr. Monroe did. He didn't anticipate when he did store his vehicles on his property before January 1, 2014 that he would be appearing before this board and asked to prove by the preponderance of evidence that he did so. He didn't take pictures of his use during 2013 to show this board that he used the property because he didn't anticipate that he was going to be here. What he has done is brought his acquaintances that are familiar with his use of the property in 2013 and his neighbors, some of his neighbors that used the property in 2013 to testify before this board, to tell the board under oath that he used this property to store commercial vehicles on the property in 2013. There's no question, if you've read the Geist decision, that if one stores commercial vehicles on commercial property, or excuse me, on R6 property, in 2013, that it was a legitimate use of the property. The Geist decision made that abundantly clear. It was an appeal to Superior Court, and the municipality lost that issue on appeal and didn't appeal it any further. Mr. Monroe submitted a number of affidavits with his appeal. He had also asked the municipality of Anchorage to reconsider. The only kind of evidence that Mr. Monroe has of his use of his property in 2013 is the testimony of people who know him and visited the property. So I'd ask that you consider the affidavits. Several of the people who wrote the affidavits will be here in the audience to testify as to their recollection of what they saw. Again, I read through some of the comments that were filed. Although there appears to be a great deal of concern among the community or the members who filed the complaints regarding the actual trucks driving on the road and the dangers or hazards that may cause the community, that is really not the issue for the board to decide. The sole issue is really, did Mr. Monroe store vehicles on his property in the year 2013? Looking through the staff report that was filed for this board, I want to point out that one of the comments I made on the appeal was that Mr. Monroe had filed his appeal, and honestly, it wasn't as clear as it should have been. But remember, Mr. Monroe is a lay person and perhaps didn't understand entirely what the issues were. But in his initial request for non-conforming use, he said that equipment that is not frequently used by his company is parked on his property. And there was a number of 5 people who live in the neighborhood know Mr. Monroe, signed and gave their addresses and said they could be contacted by the staff to verify that the property was in use. None of these people were contacted by the municipality. The municipality took Mr. Monroe's application to mean that he bought this property with the intent to use it for storing commercial vehicles, but that no actual use had occurred. But in fact, actual use had occurred, and the staff's investigation went no further than to read what Mr. Monroe had filed without talking to any of the people who had filed their names and addresses. Mr. Monroe signed an agreement to buy the property in the fall of 2013. The deed that you have in your packet is dated November 25th, 2013. For a number of reasons that are not really relevant here, they didn't close on the property till the 17th of December 2013. He took possession of the property in December of 2013, had Christmas in the property in 2013, and stored commercial vehicles in 2013. Starting as early November of 2013, the property has been used to store his commercial vehicles. So it certainly meets the requirements of being grandfathered in, and should be, the non-conforming use should have been granted. I'm going to just let the witnesses who are going to testify and then save a little bit for rebuttal at the end. So if you have any questions, I'd be glad to answer them.
Thank you, Mr. Clark. Are there any questions of Mr. Clark by the board? Yes, Mr. Ron.
Thank you. Through the chair, Mr. Clark, if I understood the latter part of your statements there, you'd indicated that Mr. Monroe took early occupancy of the property. Do you have documentation to that effect in terms of the purchase and sale agreement from the prior seller?
Well, if you notice that the deed is dated, Mr. Monroe will be here to testify as to what actually happened, but for a number of reasons, the property didn't close when it was anticipated, and the parties made a verbal agreement that he could take early occupancy in November of 2013. So there's not any written document that says that he can take early occupancy. Some of the people that worked on Mr. Monroe's house in 2013 will be here to testify to say that they helped him, move in and paint the house in November of 2013.
Are there other questions of Mr. Clark? Yes, Mr. Ron.
Mr. Chair, this may be a question for staff and the petitioner's representative. The question of early occupancy in advance of ownership of the property. For that period before which Mr. Monroe owned the property, how does that count towards the credit that we're evaluating with respect to storage on the parcel if he's not the property owner at that point in time?
I can address that.
I'd be interested in hearing your interpretation, Mr. Clark.
Yes,
as
and then
well as-
perhaps
as well
then
as
we'll
that.
wait for staff's presentation, and we can ask them after their presentation, Mr.
Thank you,
Ron.
Mr. Chair.
But Mr.
Yeah,
Clark?
I think the requirement under the GEIS is that the property be used for the storage of commercial property or commercial equipment. In this case, it was used, and Mr. Monroe used the property in November of 2013. He used it in December of 2013. He used it before he owned it, and he used it after he owned it. So the property was in use storing commercial equipment in 2013. He had permission, verbal permission from the owner to do that. So, and he had a right to buy the property. So it meets the requirements of the statute or the ordinance.
Thank you. Any other questions of the petitioner's representative? Does staff have any questions?
Mr. Chair, no, not at this time.
Okay. Mr. Clark, you have 5 minutes and 20 seconds for rebuttal.
Thank you.
Could staff now provide their presentation?
Mr. Chair, members of the board and the public, my name's Jillian Inglis again, and I'll just go through the appeal points and reestablish what we're looking at. We don't dispute that the Geist decision located or starting on page 42 allowed for, granted Mr. Geist the ability to store not municipal, but commercial vehicles on his property in an R6 zone property as long as it was not associated with a home occupation. So there's no dispute that in an R6 before January 1, 2014, you can have commercial vehicles on the property as long as you weren't operating some sort of home occupation. So I want to resolve that issue in case the board is concerned. In regard to appeal point number 1, the MOA failed to investigate or determine whether commercial vehicles were stored on the property in 2013. We received an application, an as-built survey, letter dated November 17, 2014, and I believe that's in the petitioner's packet starting on page 13. We also looked at the zoning of the property, reviewed the property appraisal records, reviewed the warranty deed, and the code enforcement complaints, and looked at the old and the new Title 21, because if he legally establishes it in under the old and it's no longer permitted under the new, we could establish legal nonconforming rights for the use of the property. So we had to review both codes. Is it permitted under the new code? Was it permitted under the old code? And so that's what we did. The response that I have in regard to that is that it's the applicant's responsibility to establish legal nonconforming rights for the use of the property to store the commercial vehicles on the property. We weren't there in December or November 2013, and so some type of evidence needed to be supplied to us. And so we really didn't have any evidence that led us to believe that there was actually the commercial use on the property of storing the vehicles. The MOA failed to discuss the matter with Darren Monroe after the I'm just going to say non-conforming request was filed. The legal counsel was referring to it as a variance. I'm just going to interject nonconforming because a variance was never applied for. It was a nonconforming determination to establish the use. The department received all the information from Mr. Moreau, evaluated the information, and wrote a letter. So we timely provided him a letter. So I'm not sure what else. There may have been some discussion between staff and Mr. Monroe at some point, but at some point, some additional information, I believe legal counsel provided some additional information, and we still believed at that point that there was not sufficient evidence to show that there was commercial use of the use of the property for storing commercial vehicles on there. No, we did not call the people on the list. We didn't. They weren't providing anything but a signature on a piece of paper. We can evaluate that statement and go forward. There was, although the people were signing the letter, you know, there was nothing to corroborate that information, and so we just continued to believe that the property did not have there was no established use on the property, or there was no evidence or anything to show us that it actually was established. We did reconsider the decision on appeal point number 4, and we did not believe it was proved. So we did provide that. We looked at the Geese decision, and we do not dispute that in 2013 the Geese decision would have allowed Mr. Monroe to have commercial vehicles on the property. And so that goes into appeal point number 5. And then appeal point number 6. And I just want to reiterate under appeal point 5, the code changed from the current language, from the old code to the new code, where it was very clear that commercial vehicles were not permitted to be stored on the property as of January 1, 2014. Like I said earlier, we did review the codes and determined that he did not establish the legal nonconforming rights. In regard to the additional information we received in February of 2015, we were, the entire time through this process, we kept hearing differing information from neighbors, because we did have code enforcement cases open on our case open on this property, and so some of the neighbors were saying that the use was not established. And so when we reviewed the affidavits, some of them were what I'd call a boilerplate affidavit. Most of them were similar. It was more like you just attested to the same facts. You know, each person may have had different situations. A date was not clear in any affidavit, even though it said they were established at the end of 2013. All of them were attesting to this very same facts, and it lacked some credibility without any other evidence to bolster the case. So in the end, the department still recommends that the zoning board does not establish, upholds the director's decision and do not grant the appeal. If the appeal is granted, we recommend that the department put a condition, that the zoning board put a condition of approval to limit the scope and scale. And this is what we do whenever we write a nonconforming determination. We will limit the scope and scale for a nonconforming use. And so, as identified on staff packet number 7, if the board approves this appeal and grants the petitioner nonconforming rights, we would request that you limit the scope and scale as they have been trying to demonstrate in their packet. At this time, I have no further comment.
Thank you, Ms. Ing. Thank you, Ms. Ing. Yes.
Mr. Chair, I do want to respond to, I forgot whose question it was, but the use, a nonconforming use can follow, it stays with the property. So if the previous owner had established, and in this case nobody was trying to say that the previous owner was storing commercial vehicles on the property, but if the previous owner had established nonconforming rights, or at least had been doing it and later established it, the use follows the property, not the owner. So you could have, in this case, the previous owner storing vehicles on the property and somebody else purchased the property, and then they store their vehicles on the property. As long as the use remains the same, non-conforming use, then they can continue the use. It continues with the property, not the owner. Oh, and one more thing in regard, Mr. Monroe, when he established, or when he wrote to us, and even in the petitioner's packet, the comments made was that he intended to use the property to store the commercial vehicles. And so you'll see in the packet where I acknowledge that the intent to use it doesn't necessarily mean that the use was established. That concludes my comments.
Thank you, Ms. Inglis. Are there any questions of staff by the board? Yes, Mr. Ron.
Thank you. Through the chair. Ms. Inglis, request some clarification. I apologize for not connecting the dots. Early in your presentation, you brought about the issue of home occupation with respect to the Geist case. Is there a difference that the board should be aware of with respect to the case we're hearing now versus some findings that may be drawn from the Geist decision with respect to home occupation?
Through the chair, Mr. Ron, at this time, Mr. Monroe indicates that he's not using the property for a home occupation. I believe in some of the documents you'll find that he and his wife both have a CDL license so they can drive the vehicles, but they're not operating their business from the property. So how this differs from the Geist determination was that the Superior Court determined that based on the old code, you could have commercial vehicles in the R6 zoning as long as you weren't operating a home occupation. So the Geist determination differs in that and Mr. Geist was not operating a home occupation either, but they clarified for the department that if they have a home occupation, they can't have any visible evidence under the old code. But if they were just storing the vehicles there, they were permitted to. So these are similar cases. Neither one of them were operating a home occupation to our knowledge. Does that clarify?
I believe so. Thank you.
Are there other questions of staff? Yes, Ms. Dole.
Thank you, through the chair. You've referred to the non-conforming use following the property and not the owner, and you've also referred to the owner being the one to establish non-conforming use. However, I guess my question is, are there any limitations, or what's your position regarding two persons who operate through the authority of the owner, whether it be a tenant or someone else that has the permission of the owner but is not the actual owner of the property, in terms of establishing non-conforming use or not? That through the owner, with the owner's permission, the owner being the one requesting it.
Well, at the time that Mr. Monroe requested the non-conforming determination, he was the owner of the property. In regard to if the previous owner had allowed Mr. Monroe to place the commercial vehicles on his property, then we would need, when we do non-conforming determinations, we rely on aerial photography, because you may find a structure has been there before, or the use. You can look at the aerial photography and see that vehicles were stored on a property or commercial vehicles. And in this case, the snapshot is so fine that it's difficult to tell. But the previous owner could have granted Mr. Monroe the ability to place the vehicles on his property, and under the code at that time, it would have been permitted.
Thank you. I don't have any other questions.
Thank you. Ms. Eicher, and then Mr. Ron, Mr. Hart. Ms. Eicher.
Thank you. Through the chair, Ms. Inglis, I appreciate your testimony. I have just a couple more questions. I was wondering if you could speak to the quality of evidence, or I guess the preponderance of evidence, given we have such a short, narrow time frame that we're essentially looking at 11 days if you go by the date at which the deed transferred the property, since we don't have evidence of a rental agreement, or we haven't heard testimony yet. I guess I'm just anticipating what issues may arise. If we can push that date back further, then that would, of course, give me more comfort to look outside that zone. But I'm looking at those 11 days. If, for instance, we had an aerial photograph that had trucks parked there on December 30th, would that then satisfy the requirements that you would need in order to find that use had been established prior to the January 1st, 2014 deadline? Or are you in fact looking for something more concrete?
We look at a variety of information. An aerial photography may not be the only thing. An aerial photography in connection with statements or other pictures or some type of agreement or all of that. We look at all the evidence together to show, did they establish the non-conforming use on the property? So just one day, that's a snapshot in time too. It's difficult, and I can tell you we grapple with this all the time in our department. And we are talking about 11 days if we look at the fact that he's picked up the property on the 20th officially. And we have no other information to say that he was actually in possession of the property prior to that. So we look at a variety of information, and we try to make a determination based on all of that. So it's difficult. We may have looked at an aerial photograph and the affidavits and some other things.
Thank you.
Thank you. Mr. Ron.
Thank you. Through the chair, Ms. Inglis, can staff comment on the site survey that has been replicated multiple times throughout the staff packet? Does staff have knowledge of who originated the hand-scribed comments and drawings on the Shane Holt survey dated December 15th, 2013? Do you know, was that the surveyor, or was that after the survey was complete and stamped?
I believe that, the original survey showing the house and whatnot is Mr. Holt's work. But then the hand drawing, I don't know for certain, but it's likely from the applicant showing where he was placing the vehicles on the property and showing some trees along the road. So I believe the house and the driveway are the original work, and then something added on later to show us where he was placing the equipment and vehicles.
A quick follow-up to that. We see some notation underneath the as-built drawing with the language "to be parked," noting that the date is December 15th, 2013. Would staff care to comment on the use of that language with respect to the date and how that may or may not weigh in on the status of when vehicles were parked?
Go ahead.
My name is Robert Gray. I'm the one that did the determination letter. And so from the beginning, when the applicant came in, it was my understanding that the reason they purchased the property was for the intention to use it for commercial uses. And so this survey that says "to be parked" more or less reinforces the idea of the intention for purchasing the property. And it was my belief that they believed that if they purchased the property prior to January 1st, 2014, that established the permitted accessory use to park commercial vehicles, because we're seeing a timeline here of crunching everything before January 1st, 2014. So I'm fairly certain that everybody was aware of the code change. And when I reviewed the information presented, we had a list of people presented at that point in time with the application, that these were the people that did not object. These were not the people that said it was there. This was a form that basically was saying, we do not object, in a list of people. And as Ms. Inglis pointed out, we do not contact people outside of the applicant. The applicant, if they want to provide additional information, but the burden of proof is on the applicant. It's not on us to go out and do research out of our municipal facility. And this is the way we work in general.
Through the chair, Mr. Ron, I believe that the December 13th, I believe this was actually submitted with the nonconforming determination request in 2014. That, likely there was some type of survey done in 2013 to show the house, and that when Mr. Monroe was applying for nonconforming rights, he wanted to show us where he was putting the vehicles, and therefore he edited it, and that's just my best guess. I don't have personal first-hand knowledge.
Thank you.
Yes, Mr. Hart.
Thank you, Mr. Chair. I guess my question is in relation to the records for Monroe Enterprises. With the Department of Commerce, is there a date of address change related to that we know
of? Through the chair, Mr. Hart, I checked the records today that the records do not show this house as an address for the Monroe Enterprises.
I thought I read somewhere in the packet that it was listed as the address for the business.
The house? I don't believe so. I didn't. We can ask that question of Mr. Monroe. But when I looked at the records, business records today, it didn't show Monroe Enterprises as being located at this property. He has another I-1 lot.
Did that answer your question, Mr. Hart, or you?
I'll look through the packet to see if I can find it. I thought I read it somewhere in the packet, though.
Okay. Did staff have I had staff next in the queue. Was there another response to a question we'd asked?
No.
I do have a question. We've been given comments today from some of the, it appears, residents that live along Wagner Street, and a number, if not all of them, are in relation to the traffic associated with the trucks, the construction-related equipment. We heard from the petitioner's representative or the appellant representative that those comments are not an issue or relevant for the board to decide this evening. Is that staff's impression or is contention of these comments as well?
You can take into account, Mr. Chair, the comments. However, the board should focus their view on if the nonconforming use was, by a preponderance of the evidence, was a nonconforming use to store commercial vehicles on that property existed prior to January 1, 2014.
Thank you. Are there other questions? Yes, Mr. Vig.
Thank you, Mr. Chairman. Ms. Inglis, I'm looking at the first page of the packet at the bottom, it refers to Table 2105-3, the table of accessory uses. And I'm looking in my book with the table in it, and maybe that I'm looking at an outdated version. Mine's dated December 3rd, 2013, in the lower right-hand corner. But in the R6 district, it would appear that parking of business vehicles outdoors, accessory to a residential use, is permitted.
Through the chair, Mr. Vig, the question here is commercial vehicles. In this case, parking of a business vehicle outdoor, many companies have a truck that has some type of logo on the side of the vehicle, or something that is not classified as a commercial vehicle, maybe a small van or something associated with a business that they drive to and from. Under the old code, there was a lot of debate on if these could be, because it was visible evidence of a business. But in this case, the business vehicles is different than the of commercial vehicles. It's a smaller type vehicle.
Okay, so I don't even see a category for commercial vehicles in that table, is it?
If I could clarify, apologize for stepping in. This is Erica McConnell, current planning.
Thanks.
The definition of parking of business vehicles outdoors accessory to a residential use is the outdoor storage or parking of a vehicle used for and or bearing visible evidence of a commercial business purpose, but not regulated by subsection 2105-070E7. And that referenced section is in the prohibited accessory uses and structures section, which is parking of commercial vehicles outdoors. And that section states, the outdoor storage or parking of a vehicle or trailer is prohibited in all residential districts for a period of 1 or more nights if the vehicle or trailer is licensed or regularly used for business purposes and is either A, a vehicle for which a commercial driver's license is required by state law, B, a vehicle or trailer having more than 2 axles, C, any trailer bearing commercial signage, logo, or carrying commercial or industrial equipment or materials, or D, a vehicle or trailer having a height in excess of 90 inches, or E, a vehicle with a gross vehicle weight rating of more than 12,000 pounds. So as Ms. Inglis stated, the intent of the allowed accessory use is more for things like, a truck with a sign on it, or a van, or the smaller vehicles that could be passenger vehicles but are used in a business purpose.
Okay.
Thank you.
Thank you.
Through the chair, that's also found on page 5-122 of the latest printed version of the code, down at the bottom.
Are there other questions of the staff by the board? Seeing none, does the appellant have any questions of staff?
In your, I have one question regarding the request for reconsideration. Did staff evaluate the affidavits in the request for reconsideration?
Through the chair, at the time we received the request for reconsideration, the affidavits were not submitted, if I recall. The affidavits came in on February 12th, and the reconsideration request was sent. Let me find that real quick. To us on January 23rd, 2015. So that's what we evaluated at the time of the reconsideration.
So the answer would be no, you did not evaluate the affidavits as part of the request for reconsideration?
No.
There's no question in this case that Mr. Monroe is using is not using the property for home occupation, is there?
At this time, we have no belief that he's using it. We don't have any evidence he's using it for a home occupation.
And outside of photographs and writing such as a lease or early occupancy agreement, what other kind of evidence does staff rely on when making a determination?
Sometimes it can be titles, it can be a whole host of different things that the applicant can provide. And in this case, we had differing comments coming in from differing people in the neighborhood. And so we could look at a lot of things. A lease agreement, if a title changed to put that vehicle up there, that nothing was submitted to us that indicated that. So anything, even tax records we've looked at, there could be a whole host of things.
So staff did a background check on tax records, the photographs, and a rather extensive background review of the property, did it not?
No. In this case, it's incumbent upon the applicant to submit the information. So if the applicant had that evidence, they should have submitted it with their application.
But
We don't have access to tax records unless the applicant provides it to us.
Staff did do an investigation of the property, did it not? If we look through the denial of Mr. Monroe's request for that his property be granted nonconforming use, there was extensive review by Mr. Gray, wasn't there, on the use of the property in the past, and who owned the property, and photographs of the property?
Yes, we review whatever the applicant submits to us to show that they have established a nonconforming use. And in this case, since it was submitted a year later, it's difficult to go take snapshots or pictures of the use, because even if it was established in December of 2014, it would not be established legally as a nonconforming use.
Mr. Monroe didn't have any idea that his property was or there was a contest over his use of the property before a complaint was made in the summer of 2014, was it not?
That's correct. A complaint was filed in, I believe, June of 2014.
And had a complaint not been filed, then Mr. Monroe could be using his property presently in a nonconforming use matter, could he not?
He could be, but it may not be legal.
Did staff ever contact Mr. Monroe before he hired counsel to inform him that if he had any other additional information, such as affidavits, photographs, or such, that it could assist staff in making a determination?
Yes. When I completed the letter, I informed Mr. Monroe, and we had brief conversations over the telephone, and he asked me what I would need. And I would say, if you have dated photographs showing us, and he goes, well, I don't have any. And so there was no, he was aware that he did not get legal nonconforming rights for the accessory use. And so he was trying to establish, and I told him, I said, well, I need something to hang my hat on. And even at that particular time, he never talked about producing affidavits of people verifying that the use had been established prior to January 1st, 2014. You know, he never said, I can get you these affidavits, would that work? And so it was only after the appeal process through the department and the city attorney that these affidavits start showing up.
Did you consider these affidavits at all in making your determination?
I didn't have them at that time. The only paper I had when I did my determination was a letter stating that these neighbors do not have a problem with this being up there. Nobody gave me an affidavit that said the use was there. They said, we do not, basically said, we don't care if he uses it for commercial truck storage.
Well, the neighbors didn't say that. The neighbors said that Mr. Monroe parked his equipment on his property, did they not? Isn't that what they said? They parked his equipment on the property? They just didn't say when he did it.
No, I don't remember seeing that.
Well, if you look at page 76 of the
Mr. Clark, could you state your question again
Yes.
with respect to page 76?
I said that the witnesses who wrote the letter said that Mr. Monroe parked his equipment on his property. Did they not? If you read the, yes? Second paragraph, last sentence.
Yes.
Did you contact any of those witnesses to make a determination as to when Mr. Monroe parked equipment on his property?
No, I did not.
Some of those witnesses will be here today and will tell you when he parked the equipment on his property. And if they don't for some reason, and if they're too nervous to remember exactly what to say, I want you to be sure to ask them when Mr. Monroe parked his equipment on his own property. I don't have any more questions.
Ms. Dole, did you have a question of staff?
Yes, I do. I would like to know your understanding of the board's task here today. I've gotten different impressions from things that have been said. For example, when one of the questions asked by a board member was whether we could consider new comments that were not before the department when it made its determination, and I thought I heard that I understood the answer to be yes, we could consider it in order to determine whether a non-conforming use was established by the deadline. But I've also heard a number of questions geared towards whether the decision, whether suggesting that our role is to determine whether to uphold the decision based on what the department had when it made its determinations. So I guess I would like to know your understanding as to the board's role today. Is it to consider factual evidence, all the factual evidence, including new factual evidence, kind of de novo, and make a decision based upon it, or is it to consider the adequacy of the decisions that have already been made based upon the evidence and the job that was done at the time in making those determinations? Thank you.
Through the chair, Ms. Dole, the board can consider new evidence if there's new information. presented tonight, the board can consider that in its findings, and if they believe, they can approve the appeal and grant the petitioner non-conforming rights. You can also make findings that maybe there wasn't sufficient evidence at the time the determination was made, but new evidence has come to light, and the board can make that determination if they so choose in their findings.
Thank you.
Thank you. Mr. Ron?
Thank you through the chair to staff. I believe we've already covered this, but there seems to have been some backtracking perhaps on it in recent discussion. Who holds the burden for establishing the non-conforming rights in this case?
In this case, the applicant, so Mr. Monroe, has the burden to show the proof that the use was established prior to January 1, 2014.
Thank you. I raised that question with respect to the petitioner's representative line of questioning with respect to the letter on page 76. I'll step outside of that burden question and ask more of a general question as a layperson, if staff would be willing to respond. The statement in question at the end of that second paragraph is equipment that is not frequently used by his company is parked on Mr. Monroe's property. In reading that statement, are there any ties to the timing upon which, with respect to 2013 versus the present, that vehicles were or were not parked on the property?
Through the chair, Mr. Ron, can you please identify which statement you're talking about at the moment? I missed it.
Sure. Ms. Inglis, page 76, second paragraph, last sentence. Again, for the record, equipment that is not frequently used by his company is parked on Mr. Monroe's property, noting the date of that letter is November 17, 2014.
Yes, the date of the letter is November 17, 2014, and yes, that statement is there. The property at 12201 Wagner is not used as a work yard, so they're trying to establish that it's not commercial use on the property other than the storage of the vehicles. Equipment that is not frequently used by his company is parked on Mr. Monroe's property. I may have missed your question. Can you please restate it?
If staff is willing to respond to the question, my interpretation of these statements is that they're present in time to the date of the letter.
Yes.
And not reflective of historical action.
Let me read the letter real quickly, please,
Sure.
because the date of the letter is November 17th, but I want to make sure that is true. They are making a current is statement, meaning currently as of that date. Based on that statement, yes.
Thank you.
I had planning staff in the queue again. Was there another statement or comment? Okay. Is there any other question? Are there any other questions of staff? Okay, then the hearing shall be open for public testimony. Again, anyone wishing to testify, come forward, understanding you may be questioned by the board, staff, or the appellant. So if you wish to testify, please come forward. And if you will state and spell your name for the record, please.
Darren Monroe, DAREN MUNRO.
Thank you, Mr. Monroe.
I'm the owner of 12201 Wagner. We looked at buying that property. We started this process in September of 2013. There was a couple issues due to septic situations and other property sales to buy this property that took a little bit longer than we anticipated to close. We talked to the owner. He let us take possession in the beginning of November. I don't remember the exact date. Once again, I didn't think I was going to have to be here trying to prove all this. At the time, we had wanted R6. I'd want to be able to park commercial equipment, not a huge amount. I have a commercial yard, I-1. That's where my office is. We actually have 2 commercial yards. It was never in my intent to buy that, to make that my sole commercial business, that parks everything I have there. We just would like to be able to park stuff we're not using, or if I'm out working and I want to come home, spend the night, go back the next day to work, stuff like that. It was never intended for me to make it a commercial truck yard per se, with a lot of traffic going in and out. After we took possession of it, they let us move in early to do painting, stuff like that. We were going to buy it for sure. He didn't have a problem with that. We parked commercial stuff there. And I have witnesses that it was either working on it or drove by neighbors that proved that in 2013 we had stuff stored there. We were completely moved in. We had Christmas there. And when we first started looking at this property, I was unaware of the new Title 21 to where we couldn't park commercial stuff there. I didn't know that it was changing January 1. It wasn't, oh, I got to get this done by January 1st to try and beat the rules. That wasn't the issue at all. I wasn't aware of all the situations until the MOA guy came and informed me that that was what the deal was. Once again, we just want to be able to store stuff. It's a 2.25 acre parcel. There's adequate room. I have a big motorhome, 4-place trailer. It's just ideally what we wanted. And I didn't know that I was going to have to take pictures of everything to prove that I was there. So he's asking for the burden on me to prove. If I would have known that the Title 21 was going to change and I was going to have to prove that, I would have took pictures. Thank you.
Thank you, Mr. Monroe. Are there any questions? Just one sec. Are there any questions of Mr. Monroe by the board? Yes, Mr. Ron.
Thank you, through the chair. Mr. Monroe, did you hand scribe what we see on the as-built survey stamped by Shane Holt and dated December 15th, 2013?
I didn't, but Hazel did. She's in the audience.
Could you? I didn't catch your response there, Mr. Monroe.
I didn't write that. I had my office lady write that, kind of a diagram. And maybe it wasn't worded exactly the way it should have been, but at the time I didn't really think this was going to be an issue. I didn't think it was going to be any kind of a situation and go this far.
Will Hazel be testifying tonight?
Yes.
Perhaps I can ask her the questions. Thanks.
Thank you. Ms. Eicher?
Thank you, through the chair. I wonder if you could explain to me a little bit more about the circumstances for your intent to purchase the property and the delay for recording. And it's a little surprising to me, and perhaps there is absolutely no evidence, but I'm just wondering if the property owner let you move in early. Was there any type of consideration given? Did you pay a portion of the property taxes? Do you have maybe not a full-blown rental agreement? Do you have an email correspondence or exchange, liability waiver, or anything?
We just had verbal. The only thing we had written that it was in there that he was going to let me in to paint the property to get it ready. That was written before.
In your purchase and sale agreement?
Yeah, but as far as parking the stuff there, that was verbal, or I would have brought all that with me.
Mm-hmm. So he knew you were going to have heavy equipment or trucks, trailers. He wasn't worried about pollution
Correct.
or anything?
We were buying that place. It just, things got held back a little bit due to closing on another piece of property and due to the septic situation had to be resolved.
Thank you.
Thanks.
Ms. Inglis?
Mr. Chair, I didn't want to jump in front of the board. Is there any more board members that have questions at this time, or I'm trying not to? Okay.
Let me ask that question. Are there any other questions, any of the board members of Mr. Monroe? Ms. Dole?
Could you just, to the extent you recall, could you tell us how often, how many or what types of vehicles, what types of vehicles, commercial vehicles you have that you were keeping there in the beginning?
It kind of varied. Once again, we're talking about from, the beginning of November to December 31st. It wasn't like what's on the diagram was there the whole exact time. Sometimes we would move a trailer in and out, or one night I'd bring sand all night, bring the sand truck home, sleep for a few hours, go back. There was, for the most part, there was 2 side dumps in one pup trailer. I don't want to park any more than 3, what they recommended. As far as I don't have any intention of having a big truck yard there. So the recommendation of 3 vehicles, commercial vehicles, is fine with me.
I don't have any other questions.
Thank you. Mr. Vig?
Thank you. Through the chair, Mr. Monroe, do your vehicles, these commercial vehicles, are they loaded at times when you're driving up Wagner?
The only time they were loaded is when we were redoing the driveway. I've done extensive amount of work on that place. We have redone the whole driveway. We've done landscaping. We're putting up a fence, doing more landscaping this summer to make it nice. We put a huge amount of money in the place. It's our home. We want to make it nice. We're not trying to devalue the property or make it to where it's, commercial yard. We just want to make it nice.
Mr. Monroe, you touched on sanding, being that this was in November, December time frame.
Correct.
What would be the reason for you having trucks there in the winter? Do you haul snow in the winter? Do you?
The reason I have a sand truck, like if I was out sanding all night and wanted to go home and take a few hour break and go back out again or something, and take it there and park it. Once again, it's not my place of business. I have an office with I-1 Yard where most everything is. But we bought that place with intentions to be able to drive a vehicle home, to stay the night and drive it the next day, or vice versa. That's why we chose that area. That's why we chose that lot. That was the full intention.
No, and I understand your intention. In my mind, there's a question of timing and when equipment started to be stored there. I was just trying to understand. Do you haul? Does your company haul snow in the winter, or
we do haul
what would
snow.
the reason for that equipment to be there?
We haul
Would you be
snow.
driving that equipment?
At the time, there was another person in my commercial building that moved some stuff in there, and we moved some things around to accommodate stuff that he was doing. He's no longer in the building anymore, so I have more room at my I-1 location. We have another I-1 location, so it's just, it wasn't set that we're going to park this vehicle here for this time. It was just kind of on a as-needed basis, depending on what was going on.
Thank you. Any other questions of Mr. Monroe? Sorry. Ms. Inglis.
Through the chair, Mr. Monroe, are you operating a business from the property at Wagner?
No, my office is at 8726 Corbin Drive. We also have another location down at Post Road, but the main facility is on Corbin Drive, which is I-1 location.
Through the chair, do you have employees that come up there to pick up the vehicles, maybe in the middle of the night or anything like that?
We don't really want to do that in the middle of the night. We have people come up and we'll swap out stuff during the day, but it's not a 24-hour full go operation there. That's why I have I-1 property.
Do you have a dispatch or anything from the house?
No, I am a business owner, so occasionally I have to take calls and I'm at home, but that's what my office for is, that's my place of business is at my office.
Do you recall when you had your office personnel write the layout located on page 41 that shows the Shane Holt as-built survey with some hand-scribed drawing on it? Do you remember?
I don't remember the exact date. Once again, I didn't think I was going to have to go through all this process, so I didn't think it was, I was going to have to keep track of all the dates and take pictures and all that type of stuff.
Through the chair, do you remember when you moved in or occupied the house?
I'm guessing it was right around November 20th, November 15th, right in that area, give or take.
And do you recall when you first started parking the commercial vehicles on the property?
Around the first week to the second week in November, as soon as we got permission from the seller to be able to occupy.
And you say you have an email from the seller allowing you to go in and paint. Did you bring the email tonight?
That was on, I believe that was on a purchase agreement, and I tried to look to find a signed purchase agreement, and my real estate agent said he has an agreement that shows that we were able to get in there to paint. I didn't think it was irrelevant to this, or I would bring it because it didn't say anything about parking stuff, but I could get that if needed.
Through the chair, so the purchase agreement doesn't provide any information about allowing you to put the commercial vehicles up there?
No, that was verbal.
Okay. That's all I have. Thank you, Mr. Chair.
Thank you. Mr. Ron.
Thank you, through the chair. Mr. Monroe, what vehicles were you parking, per your testimony, in the time frame that you'd stated prior to occupation of the house?
There was a couple side dump truck and trailers, a pup trailer, a sand truck occasionally, a belly dump trailer, and a semi-end dump trailer. They weren't always there at once. It was kind of sporadic. And once again, I didn't think I was going to have to write down all the dates and document every time I took something up there or pulled it out.
Are there any other questions of Mr. Monroe? No. Thank you, Mr. Monroe.
Thank you.
Is there anyone else from the public that wishes to testify? Again, could you state and spell your name for the record?
My name is Hazel O'Hara Barnard, HazelO'_HARA-BARNARD.
O'Hara Bernard, is that right?
O'Hara Barnard.
O'Hara Barnard. Thank you, Ms. O'Hara Barnard. You can proceed with your testimony. You have 3 minutes.
Wonderful. Thank you for letting me testify, staff and board. I would like to testify that in November and December of 2013, I was involved in the process of moving the Monroes to Anchorage, to the Wagner address. I also wouldn't be able to provide you with a exact date that I was there. I know I was there in the end of the year because we had other business deals we were trying to get done and we were moving them in. So I definitely remember seeing the commercial vehicles parked there, definitely the pup trailer. Yeah, so they were definitely parked there. I am the one who drew the picture on the as-built survey. The as-built survey wasn't meant to change the as-built survey in any way. The as-built survey was more used as a template at the suggestion of Mr. Gray. And I called his office to ask what we would need to submit with the application. He suggested that we show where we intended to park things. And I was trying to show that the trailers would be still hidden by, the landscaping and the existing buildings on the property, so they wouldn't be adding to decreased property values or unappealing property, which seems to be some of the concerns of the neighbors. So just to hit that question before it comes up. That's my testimony.
Thank you, Ms. O'Hara Bernard. Are there any questions of the board, by the board? Yes, Ms. Dole.
Thank you. On page 79 of the packet, do you have it?
I don't- I
or
can
you
grab
look
it.
at it? Okay.
Okay.
I saw your name on as the petitioner representative.
Yep, that's me.
And the date on that was November 17
Yes.
of 2014.
Yes.
You just talked about talking with staff, and I was just trying to get a sense for the time frame of when you talked to them, how much before this November 17th petition, and what had happened before that petition that you were directly involved in terms of conversations or...
Before, oh, I'm sorry.
Go ahead.
Okay, sorry. So before filling out this application, how, you're asking the time period of when I was aware about this little determination?
Yes. When did you first, speak with anyone at the municipality about this?
I would say it was within about a week of filling out this application.
Okay.
It was a prompt, received an email that, we got an email that there had been a complaint about it. It was, within that week or so. And then he said, if you have any questions about the application, try to contact the office. I left a couple messages, and then I finally got a hold of Mr. Gray.
Okay. Thank you.
Thank you. Are there any other questions of Ms. O'Hara Bernard? I do have a question.
Okay.
And again, how, could you, and maybe you stated this in your previous testimony, but again, how can you be sure that it was, they were storing equipment there prior to December 31st?
I was hoping to move to the property. I know that was the date because I was working for Mr. Monroe up until December 17th, and then I was working for someone else. So I was helping him out, and then I was busy working for the other people. That's how I know that the date was definitely before the end of December.
Okay, so up until December 17th, you were working for Mr. Monroe?
Mr. Monroe, yes.
Okay.
And then it bounced back, and now I'm working for him again.
Okay, thank you. Ms. Dole.
I'm sorry, but you, the chair and you just mentioned you were working for Mr. Monroe until sometime in December of 2014, I take it, because this application on page 79 is dated November 17 of 2014, but we've been talking about the relevant time period being 2013.
I'm sorry.
Okay.
Yeah.
I just wanted to clarify. So you were working for him through 2014 until December of 2014. Then?
Do I have my dates totally screwed up? Okay.
December 17, 2013.
Okay, sorry. I'm horrible with dates sometimes, but I know that this one is for sure because can I explain the end thing? Okay, so I was working for him at the Trapper Creek Inn, which he sold December 17, 2013. So up until the end, December 2013, we were helping him move and transfer the business. So then after that, that's why it's a firm date in my head, is because we sold the business, which I was helping him with.
So that was in 2013 then?
Yes, it was
So then
December
why were you
2013. So now,
filling this out in November
So-
2014?
so I worked for the business, the Trapper Creek Inn, the new owners for a couple months, and I came to Anchorage to work for Darren again in March of last year. So I came back and worked for him again. It's a little confusing.
That was what was confusing.
I'm sorry.
The years and the months.
Yeah.
Okay, thank you.
Yep.
Yeah, Ms. Inglis.
Through the chair, Ms. O'Hara, I'm sorry, Hazel.
It's okay.
Ms. O'Hara Bernard, I'm sorry. Okay, so that was confusing, but it sounds like you started working for Mr. Monroe again in March of 2014.
Yes.
So as an employee, you were doing his paperwork for this non-conforming application on page 79. And Mr. Monroe signed it on November 17, 2014. Is that correct? And then it looks like it was submitted to us, if you look at the bottom, date application received December 11, 2014. Does that sound about right?
Yeah.
And then on page 18 and 19 is your affidavit of the packet.
Yes.
And so was this just a boilerplate affidavit that somebody handed you and you signed, or did you make, it sounds like you didn't make notice that you were working until December 13th or 17th of 2013 in your affidavit? It might have. Is this the one that you signed? Do you live near this house at all?
Well, now I do. Now I live near this house, but
Okay.
what we're saying is that I'm a friend of Darren and Jennifer Monroe on number one, and that number two, they definitely moved into their house in the end of 2013, and I observed that there were commercial vehicles parked there during the end of 2013.
Okay, so was this written for you, basically, and it like a boilerplate, and somebody just handed it to you and you went ahead and...
I did not write the affidavit out, but I did read through it and sign it. It's like a summary of what we're all attesting to, that the vehicles were parked there in the end of 2013.
Mr. Chair, no further questions.
Thank you. Are there any other questions of Ms. O'Hara Barnard?
Got it that time.
Had to get it once. Thank you. Anyone else from the public wishing to testify? Again, if you could state and spell your name for the record.
Elijah Nyland, E-L-I-J-A-H, Nyland, N-Y-L-A-N-D.
Thank you, Mr. Nyland, and you have 3 minutes.
All right, I'd just like to state that I've worked for Mr. Monroe for a while, and in middle of November 2013, I helped him move stuff from one property to another property on Wagner Street. And I also, like I said, we moved trailers there. I helped him paint there, helped him move some of his household supplies there. I can contest that we've kept trailers there since then and parked them since November of 2013. And just on and off, move stuff to and from there, but there has been trailers, standers, side dumps, tractors, on and off parked there throughout the past year and a half, however long it's been. So I guess that's what I wanted to state, that there has been middle of November, somewhere in there, we started moving stuff there. It was towards the end of November, we were painting in there. I know that, like I said, Hazel, she was the 17th, 2013. I guess that's just what I want to say, that I know for a fact there was trailers there on the property before 2014. So.
Thank you, Mr. Nyland. Are there any questions at the board of Mr. Nyland? And Mr. Nyland, again, I'll ask the same question. How are you, well, it's not the same question. You helped paint
I helped
the house
move
with
stuff
Mr.
to the property and help paint the house before they moved in.
Okay.
And it was all ready to go. Like I said, they were in there by Christmas time. They had Christmas there, everything that year.
Okay.
So.
Okay. Thank you.
Yeah.
Ms. Dole.
All right. Were those activities, those commercial vehicles there, it sounded almost like they were there in conjunction with the painting and the moving.
Yeah, we started moving everything as soon as they got the okay to move on to the property and start doing stuff to the property, we started moving stuff there, started getting it ready for them to move in.
So were the commercial vehicles being used for the business that's, you know, and I don't know much about the business, but the business that's operated out of the other locations? Or was it more were they more being used in conjunction with helping them move in and make changes to the property?
He owned other property up north that we moved stuff from there, that we were storing trailers and stuff up there too. We moved some of them trailers that we were storing up there to town, and that's where we parked them. And then, like I said, we moved them back and forth from the yard depending on what we were using or what we were doing. So.
But I had the impression that most of it was in conjunction with moving in or making changes to the property he had just bought. Is that right?
No, when he got the okay to move on to the property, that's when we started moving him in. That's when we brought the trailers over there. That's when we started painting. It wasn't just to help him move in. It was to start storing them there, to start painting there, to start moving them onto the property.
To make changes to the property, like painting, like if you move in, you might want to paint your new house or make landscaping changes. Or, okay, never mind.
Yeah.
No further questions.
Ms. Inglis.
Through the chair, how long have you're an employee of Mr. Monroe's company?
Yes,
And how long have you been an employee?
for about 7 years.
7 years. And you're currently employed with Mr. Monroe?
Yes.
And did you write or sign this affidavit located on page 24 and 25 of the packet?
Is that this one right here?
It's dated.
The affidavit that I signed, yes. I did not write it, but I did read it and sign it.
Okay, thank you.
Are there any other questions of Mr. Nyland? Not, thank you.
All right, thank you.
Is there anyone else from the public wishing to testify? Again, could you state and spell your name for the record?
Yes, it's Stephen Todd Parks, last name Parks.
Thank you, Mr. Parks. You have 3 minutes.
Thank you. I wanted to testify that, in fact, I did personally see commercial vehicles on the Wagner property for Mr. Monroe during the time frame before the end of 2013. I also helped paint the property so that the Monroes could move in there due to the hideous color that was inside of it. So that's why they keep bringing up different points of having to paint the property. There is a garage that is on the property, a 2-car garage/shop that we had to paint, and I distinctively remember this because of as far as the commercial property being there, due to having a key and had to leave it on one of the trailers that were parked on the property at that time. I had the key. Mr. Monroe needed to get into to access the garage, and asked me to leave the key and told me distinctively to just leave it on the side dump trailer, which I did. So I wanted to bring that, for instance, up so that you were aware that, in fact, the trailer was on the property during that time frame. Thank you.
Thank you, Mr. Parks. And how did you know that when you left the key on the side dump trailer, that was in 2013?
During the time frame of the painting of the house, which happened in November.
Okay. Thank you. Mr. Ron?
Thank you. Through the chair, Mr. Parks, do you recall where on the property that side dump trailer was parked perhaps with respect
Distinctively, I do.
using the garage as a point of reference?
Yes. The trailer was parked, there is a man door that is on the, as you face the garage, on the right-hand side of that structure, and the trailer was parked parallel with that building a little further to the right side of that man door. So as you face the structure to the right.
Would you classify that area, sorry, Mr. Parks, as parking for the side dump trailer?
As what? I'd say it again?
I'm curious as to how you would characterize that portion of the lot. What terminology would you use? Would you call it parking for that equipment? Is that what that part of the lot is you're claiming is used for, or has been used for in the time that you're talking about?
Yes, as I've seen more than one trailers parked there.
Thank you.
Any other questions? Ms. Inglis?
Through the chair, Mr. Parks, are you an employee of Mr. Monroe's business?
I am not.
You are not. So, and on page 30 of the packet, did you write the affidavit?
The affidavit, I did write that affidavit.
You did write that?
I did.
Thank you.
Mm-hmm.
Are there any other questions of Mr. Park?
One. And do you still live in Eagle River?
Yes, we just recently moved to Eagle River. At that time frame of 2013, I lived just next to the zoo, just up the hill from this address.
Okay, thank you.
Yes.
Are there any other questions of Mr. Park? If not, thank you.
Thank you.
Is there anyone else from the public wishing to testify?
My name is Don Smoot, spelled S-M-O-O-T. I'm a neighbor of Mr. Monroe's. I've been there about 17 years. He moved in about the end of 2013, and I guess that's all I have to say. I never knew him before then. I barely know him now. So I have no other motivation other than to do what's right.
We're ready to ask questions. Are you ready for? Is your testimony? Is that your testimony, Mr. Smoot?
That's my testimony.
Oh, okay.
Yeah. He was there by the end of 2013, and that's all I have to say, I guess.
Okay. Thank you, Mr. Vig.
Thank you. Through the chair, Mr. Smoot. So,
pardon me, I can hardly hear you.
Okay. So if he was there in late 2013, did you observe any of the commercial vehicles being stored on the property?
Yes, he had trailers out near the street, backed up behind some trees that are there.
And you saw them there at that time?
Yes.
And have you observed the damage to the road that has been commented on in the package?
Well, the road is compacted clay with recycled asphalt over it, then tarred and chipped. And we've always had problems with that one place where it came apart. I've been there for 17 years, and the road was that way the first year we were there. It's always been that way. It's a bad spot.
Thank you.
That it?
And Mr. Smoot, do you live on Wagner? You said you're a neighbor. You're a neighbor of Mr.
Yes, I'm
Monroe's.
on Wagner. I'm up the street, about 3 houses on the other side of the street.
Okay. Thank you, Ms. Inglis.
Through the chair, Mr. Smoot, on page 80 of the packet, there's an aerial photograph, and you live at 12040.
Yes.
Do you operate a business out of that property?
Yes.
How long have you not been operating the business out of there? How long have you been operating the business out of the property? How long have you been operating the business out of the property?
17 years.
And what kind of business is it?
A small landscaping company.
Okay, and you wrote the affidavit located on page 37 of the packet?
Yes.
Okay, thank you.
Are there any other questions of Mr. Smoot? If not, thank you. Is there anyone else from the public wishing to testify? Again, could you state and spell your name for the record?
Jason Wessels, Jasonwessels.
Wessels?
Yes.
Thank you, Mr. Wessels. You have 3 minutes for your presentation.
I'm here to testify that, yes, Darren had equipment at his residence on Wagner Street in 13, November, December. I don't know the exact name because I was on the painting crew of the house too. I know they were in the house for Christmas because I attended. I saw the Christmas tree and the family came up. I do live at 14633 Maxwell Place. And the trailers, due to the map, there was an equipment trailer that was by the in-dump pup trailer that backs to the street. And then there was a side dump and another truck beside the garage, or I'm not sure what it's, yeah, the garage is what it stayed on there, to the right. And when you drive in, they're behind the building, so you really can't see the whole trailer when you pull into the driveway, but there's big equipment there. Since then, like I said, I was there painting, and I'm in the trucking business, so I pay attention to the stuff when I pull in someone's driveway. So.
Thank you. Are there any questions? Yes, Ms. Dole.
Besides the painting, was there also landscaping going on?
Not in November.
Okay.
That was just, we were painting the interior of the house.
Okay. And were there commercial trucks there that were not needed for the painting?
No, there was no, the trucks were just sitting there.
Okay.
There's dump trucks and no paint.
Are there any other questions of Mr. Wessels? Ms. Inglis.
Through the chair, Mr. Wessels, are you an employee of Mr. Monroe's?
No, I'm not.
Okay, thank you.
Thank you. Is there anyone else from the public wishing to testify?
Hi, David Harper, D-A-V-I-D-H-A-R-P-E-R.
Sorry, you caught me before I could start right. Could you spell your name again?
D-A-V-I-D-H-A-R-P-E-R.
Thank you, Mr. Harper. You have 3 minutes.
Basically is I've lived on Wagner from somewhere around the early 90s. And we travel up and down the road there probably 10 to 15 times a day. And so I can pretty much attest that what everybody's been saying is correct, is the equipment moved in long before Mr. Monroe did. And then everybody was on the street was kind of questionable. Because this place had been for sale for quite a while. So everybody was kind of questionable as who bought what, where, and when. But that's kind of the end of it is what he's saying is correct. He was there all that time. So, and that's pretty much about all I got to say.
Thank you, Mr. Harper. So I'm trying to get my question right. You live on Wagner, and
yes.
Is your testimony that you did see equipment there prior to 2013?
Correct.
And again, how do you know, or in your memory, how do you know that was in 2013 then?
Well, as you mentioned a while ago, as he brought up about the road damage, it was prior to Christmas, the previous before that. So that would have been last year.
Okay. Thank you. Are there any other questions of Mr. Harper? Ms. Inglis.
Through the chair, Mr. Harper, there was road damage last Christmas of 2013 on the property. I mean, on the road.
No. It's a little bit frozen then.
It was just a little bit frozen.
What I meant was your damage to the road came up in the earliest after weight restrictions went off in spring of 2014.
In spring of 2014.
Correct.
Okay. Where do you live in connection to Mr. Monroe, please?
We're probably almost the end of the street, 11741.
Could you speak into the microphone, please, Mr.
Sorry about that.
That's okay. Thank you.
11741. It's almost to the end of the street.
Okay, I don't have that on this aerial photography. So
You don't what?
I was just going to see if I could see your house on the aerial photography, but you're further down.
Oh.
That's all I'm just clarifying. Thank you.
Mm-hmm.
Thank you, Mr. Harper. Or excuse me, are there any other questions of Mr. Harper? Yes, Mr. Vig.
Thank you. Through the chair, Mr. Harper.
Mr. Harper, I'm sorry, we did have.
Guess I didn't hear you. My hearing's not doing so good.
Have you noticed if the road damage has gotten any worse since the applicant?
The city come in and did a half rear-ended job of fixing it, but they didn't fix it. And, you know, as my understanding was at the time that when all this was going on, it was, the damage was there, but my understanding was Mr. Monroe had offered the city to fix it and they wouldn't let him, which seemed kind of strange to me because as Mr. Smoot brought up earlier, the road's been damaged that way ever since we've lived there. Essentially, you've got upswelling of water coming through there every spring. Every breakup, you have the same thing. And basically what the city did is they come in, dumped a bunch of dirt in it, rolled over it, smoothed it out, and it took some of the bumps out, but it didn't improve it.
Thank you.
Thank you.
Ms. Inglis.
Through the chair, Mr. Harper, how long have you been living in the neighborhood?
It'd be somewhere around the early 90s.
Okay, thank you.
I think that's it, Mr. Harper. Thank
Done
you.
this time?
Is there anyone else from the public wishing to testify? Again,
excuse me?
Could you state and spell your name for the record?
I'm Larry Osborne, Larryorborn.
Thank you, Mr. Osborne. You have 3 minutes for your testimony.
Okay, I live directly across from the parcel myself, and I'm the one of them that put a statement in. I have some kind of questions because I live right across from it, and I do some plowing and snow and that, and through that time of year, we had quite a bit of snow. I know Don, he hits the street, you know, so, you know, there are berms in front of the driveways and that, and I remember pushing, because I remember the for sale sign going up and nobody moving in. There wasn't much activity going on over there or anything else, and because I remember the snow was getting pretty deep in front of the driveway, so actually I pushed it out, you know, the berm and stuff like that, because I didn't know who it was. If they couldn't drive in the driveway, at least at that time. But I have a question, because I think the vehicles showed up a little bit later than what some of these folks are saying, but I can't really say exactly because, like I said, I didn't write it down or anything else. Sometimes it's kind of hard for me to, since I didn't see a lot of activity there, I didn't see them towards Christmas and that, because it snowed a lot. I didn't see a lot of activity in the driveway for tracks and stuff like that. There was some people, I remember, because Mylan's son was living in that piece of property, and I remember him moving out of that piece of property, and then the for sale sign went up, and I didn't see many people or anything else, but It was a while before the sold sign went on there, but then there was no activity. I didn't see a lot of activity. But then the trucks, like I said, the equipment showed up. And I'm not positive if it was actually in 2013 or it could have been closer to 14. But I remember pushing snow and thinking, is there anybody ever going to move in here? Because it was, to me, I don't think they moved in until after the first of the year. Because, like I said, there's a lot of snow. I pushed the snow in there. That driveway was not cleaned out or anything else. There was no activity going over there. The first activity I seen was some people over by the shed. But that, I didn't think that was in towards, somewhere in end of February towards March. That actually somebody at the garage, I should say, that actually was doing that. So I'm really concerned about that. And for having commercial equipment in a residential, I have a real big problem with that because...
Can you summarize, Mr. Osborne?
Okay, them vehicles coming out, they're coming across, he has to make a wide swing, he's pushing that road out, it's going down the ditch on my side piece of property, and that road is tore up. That road is not designed for heavy equipment, and we have a problem of amount of vehicles anymore going up and down, employees of these businesses. This is residential.
Thank you, Mr. Osborne. Are there any questions of Mr. Osborne by the staff? By the board, sorry. Yes, Mr. Ron.
Thank you. Through the chair, Mr. Osborne, have you observed Mr. Monroe hauling material in any of the have you observed Mr. Monroe hauling material in any of the equipment that he parks on his property?
Well,
the aggregate or anything in the side dumps?
I observed him when he actually improved his driveway, when they tore up the road and stuff like that. I have not observed him actually bringing material in, say like in a truck and taking it back out or anything else like that.
Thanks.
Thank you. Are there other questions of Mr. Osborne? Ms. Inglis.
Through the chair, Mr. Osborne,
Yes.
do you live at 12200 Wagner?
Correct.
And so that's across the street from Mr. Monroe. How long have you been living there?
Since 1980.
1980. Okay. Also, do you know when the previous owner moved out or left?
Well, the actual owner moved several years ago, but his son was living in there, I'd say close to September, October, probably in October when I started to see him move his stuff out.
Okay. And have you had any contact with the previous owner at all?
No, I have not. The Mylans, no.
Okay. Thank you.
Thank you. Are there any other questions of Mr. Osborne? Ms. Dole.
I was just wondering if there was anything that would help you pin down some of the time frames. Maybe, you went away for a week and it was before or after, or you had relatives come visit you and you can say, it was after they came to visit or before they came to visit. I guess I was just wondering if you could kind of pin down a little bit better.
The only thing I can pin down is I remember how much it was snowing at that time because it snowed a lot, and so we had to plow the driveway quite a bit. It just seemed like for somebody living there, there was no activity. For the amount of snow that we'd had, you'd have to see some kind of activity. I've never seen any activity around the house. Now, like I said, the garage I had. So, yeah, I thought there was a problem in the sale or whatever because there was no activity. Because there was just nobody around.
Okay, thank you. I don't have any.
Thank you. Mr. Vig.
Thank you. Through the chair, Mr. Osborne, you mentioned a lot of traffic coming in and out of the larger trucks and things.
Correct.
Is it more than, significantly more than, the vehicle coming home late in the day and spending the night there and then going out again in the morning? Is it they come in and, another driver comes and picks it up and goes? Or?
Yeah, well, for a while there was a high activity when he first came in there. Like he said that he had several people bring some stuff in and that and come out. But my concern is not only that lot is what's happening, is it's also lots down the road. The amount of people coming in with the equipment of businesses back and forth and employees. So with that road not being, it's on clay and they just put a little gravel with tar on it, and I have a water problem with it. I think because of the damage it's done that I actually have some problems. But yeah, with that truck pulling out and have to go into almost in my ditch to make the turn to get on, Wagner Street is not that wide. So it's not made for these long trucks.
All right, thank you.
Are there any other questions of Mr. Osborne? Thank you. Is there anyone else from the public wishing to testify? Could you state and spell your name for the record?
Hi, good evening, everyone. My name is Ryan Stencel, spelled R-Y-A-N. Last name is Stencel, S-T-E-N-C-E-L. Most of the time, I'm here representing a client or the Anchorage Soil and Water Conservation District, but tonight I'm here personally. Mr. Monroe is our new neighbor. I live on Wagner Street at 12,000 Wagner. As everyone has clearly said tonight, he was, in fact, on the property by November of 2013. Other than the packet itself actually says on page 4 that the date in question was that he had to be there by January 1st of 2014. So he clearly makes that timeline. And there were commercial vehicles from the beginning. He started improving the property right away. It was in pretty poor condition and had sat vacant for a long time. And the improvement to the property is enormous, for all reasons, but also for tax reasons and everything else. It's a good thing for the whole community and for our street. I would say another couple of things. I'm not sure why he's being held to the new Title 21. I'm one of the only private contractors that worked on Title 21 process for those 12 to 15 years of agonizing process. And I spoke with an assembly member a little while ago. They gave an extension to the new old option here a few months ago, and she is feeling confused why new code is being imposed at this point anyway, but I don't know that that really matters in this case, that tonight it's just going to come down to whether he was there before January 1st. So that little bit of an aside on that part. I would also say that just from my discussions with Mike Walters and street maintenance themselves in my work side of my life, Mr. Monroe did offer to fix the road, as with some other construction that's gone on in the neighborhood. We have a lot of groundwater, and any work that's done in the area with big trucks does damage to the roads. Mr. Monroe was going to come in and fix the road when he was done. However, street maintenance stepped in prior to that and committed to fixing the road and bringing it up to standards. A few years ago, they went into the next road to the west of us, Gander Street, and brought it up to code. After same situation, someone bought a property, big trucks, did the same thing to the road, but they didn't bring Wagner Street up to code at the time. And so they're going to be doing that this year.
Thank you, Ms. Stencil. Could you summarize, please?
Actually, that's it, unless anyone has any questions. And if necessary, if we want to continue this, I can go through some aerials and that sort of thing that I have from the end of 2013 that can show the activity on the property, if you'd like.
Thank you, Ms. Stencil. Ms. Eicher.
Thank you for your testimony, Ms. Stencil. It actually isn't clear that the petitioners parked vehicles on the property before 2013, and that's why we're here today. So if you have specific testimony that can help shed light on why you believe you saw commercial vehicles on his property before 2013, that would be helpful to us.
Oh, yes, very much so. As soon as he started with the property, Christmas shopping and all of that, and I have some health issues going on, and so I'm homebound majority of the time now, which most people don't know, and it isn't public knowledge. But definitely in November of 2013 is when he started upgrading the property, especially the driveway and all of that. And even prior to Mr. Monroe buying the property, the people who owned the property prior to that had commercial usage of that property and had commercial snow plows and that sort of thing on the property through the years too.
Thank you. Mr. Ron.
Thank you. Through the chair, Ms. Stencil, you provided testimony to the fact that you have some aerial photography of the time in question. That is something that I would have interest in taking a look at from an evidentiary perspective. Is that something you can provide here tonight?
I'm not prepared tonight. My computer had to go into Pyramid today, Windows update and all of that. If the board wants to postpone, I can submit before the next hearing. Otherwise, if the board is ready to proceed tonight, I can just send it to you personally, just as a follow-up.
Well, again, if we do choose to act, we have to act on the evidence before us this evening.
Yes.
So,
in your testimony, Ms. Stencil, you spoke about early improvements to the property in November timeframe, which we've heard testimony tonight would be prior to closing. You talked about improvements to the driveway. Did I capture that correctly?
Yes.
Is your testimony stating that
yes,
Mr. Monroe started improving the driveway prior to occupancy?
He did all kinds of things on that property. It had been severely neglected over the years by the prior owner. And so there was everything from painting to the driveway to a new culvert under the driveway. Quite a bit of fill came in. It was just the driveway and the circular driveway that was in for the prior owner's commercial vehicles was basically solid mud. And Mr. Monroe upgraded all of that area.
Okay, we only heard prior testimony about improvements with respect to the house itself, painting. And so this, unless I missed something, is new testimony to me, and I'm interested in it for the fact that it may show a connection between the actual existence of heavy equipment at that time. So perhaps I'll seek some more information about those activities. In your general knowledge of a real estate transaction, is that something that you would think would typically be captured in purchase and sale agreement or early occupancy or documentation?
Yeah, very much so. In any code enforcement case that I was dealing with, the date of occupancy would be what I would go with, not the actual sale date. As far as large animals or any of the other code enforcement cases I deal with,
okay, again,
it would be date of occupancy, regardless of ownership, if it was a renter even.
Yeah, my question, Ms. Stencil, is with respect to those improvements that you've talked about and the actual documentation associated with them. So,
Ms. Inglis.
Through the chair, Ms. Stencil, is it routine to do driveway improvements in the wintertime, or do you know if Mr. Monroe got a driveway permit at that time?
I'm not sure the timing on his and all of that. I see people do improvements to their properties throughout the year, as you know. But I think that his improvements at the time were pretty limited, so that his vehicles could, and their household goods and everything else, and the bigger trucks get into the driveway without going into the ditch and what was left of the rotten culvert and that sort of thing.
Through the chair, Ms. Stencil, do you have a copy of the packet on page 74? Towards the bottom, under the case note 8/21/2014. Mike Walters right away sent me an email, right away permit number R141434. So that's likely the driveway permit in 2014 for the driveway improvement?
Eventually, yes. Work did start, and there was a stop work order issued prior to that I know of.
Okay. Do you know when the stop work order was posted?
No.
Okay.
No. I'm just a neighbor in this one. None of my business.
I understand. I understand. Thank you, Mr. Chair.
Thank you. Are there any other questions for Ms. Stencil?
Thank you. Have a good night.
Yes. Yes, Mr. Monroe.
I'd just like to clarify something. Probably what she's seeing is we had to make it a little bit wider to get the equipment in to do the septic prior to closing, and that's probably what she's seeing, why the road was wider and we had to do some septic work.
Okay.
I just
and
wanted to
just
clarify
for our record, you again are David Monroe.
Darren Monroe, yes.
Okay.
Thank you.
Thank you. Is there anyone else from the public wishing to testify? Oh, Ms. Inglis.
I'm sorry, Mr. Chair. I'd like to ask Ms. Stencil one more question about the aerial photography.
Sure.
Yes, ma'am.
What aerial photography were you looking at on the computer?
Well, I've got several. We pull from AeroMap, Aerometric, and I guess they're another name now. We pull from them a lot. But I also had a private pilot fly that area in the South Anchorage Sports Park during that same time frame, having to do with the Anchorage Woodlot.
Okay.
And so they got some. They are based out of the Cange Airstrip, which is one street up. And so we may have caught it on the way through.
Okay. So there is you're claiming there is aerial photography in November or December 2013 that shows commercial vehicles on the property?
There should be, and I had volunteered to go through.
Have you
AeroMap, Aerometric, whatever they're called today. They generally fly 2 to 3 times a year the entire city, so that they get one with all the leaves and then once without all the leaves, so that you can see clearly what's on the ground.
I think they normally fly September and May of the year if they fly. And so you had a private pilot fly nearby there?
I did.
And did you actually look at the aerial photography before coming here today?
No.
So you don't know?
No, I actually wasn't prepared for coming to this hearing until about 3 hours prior.
So you don't know if there was any activity on the property based on the aerial photography?
No, but I can check with the pilots up there and that sort of thing if everybody wants, or if you want to postpone dealing with this matter. I can look and see what I can find.
Are there any other questions?
No, there are no other questions.
Thank you, Ms. Stencil. Is there anyone else from the public wishing to testify? Anyone at all? With that, that's a conclusion of the public testimony. Seeing and hearing no one else. Staff, does staff have any rebuttal?
Hi, Mr. Chair. Tonight we heard a lot of testimony, and but we didn't see any purchase agreements or anything verifying that Mr. Monroe could take possession of the property prior to the date of sale, or the date that it was recorded in December 20th of 2013. Also, the aerial photography noted we don't have any indication that it actually shows anything at this public hearing tonight, and we conclude that there still has not been a significant amount of evidence that shows that the property was used for storage of commercial vehicles prior to January 1, 2014. I'd also like to point out on page 8 of the packet, the municipal attorney has weighed in. For the new Title 21, there was a time period that you could select, the older the new Title 21, in asking for an entitlement, such as a permit or a conditional use. Enforcement of Title 21 began January 1 of 2014, and also you'll note at the bottom paragraph that non-conforming determinations is not considered an entitlement, so you either have it or you don't. So every non-conforming determination that we've been doing since January 1 of 2014 has been based on the new code, determining if they have grandfather's rights, or non-conforming rights, I should say, to the new code. And so at this time, the municipal attorney has weighed in and said that the new code applies in this case. I have no further comment.
Thank you, Ms. Inglis. Mr. Clark.
Thank you, Mr. Chairman, board. Once again, I'll be fairly brief. The evidence is what we have. I mean, it'd be nice if we could walk in today with
thank you.
Photographs showing that there's vehicles parked on Mr. Monroe's property in November and December 2013, but he wasn't expecting to have this contest, and so we don't have any photographs. It would be nice if we had an agreement that said that in writing, that said that Mr. Monroe had the right to early occupancy in November of 2013, but he made a verbal agreement. And we know that he made a verbal agreement because we have the affidavits from the various people who swore under oath that they saw vehicles parked on Mr. Monroe's property in 2013 in November and in December. We know that there were commercial vehicles parked in November and December of 2013 from many of the witnesses who testified here today. That's the strength of Mr. Monroe's case, is testimony from the witnesses. The testimony is almost unanimous in effect that the vehicles were parked, commercial vehicles were parked in 2013. There was one witness, Mr. Osborne, who tested, but his recollection, in my opinion, was not altogether clear when it was that Mr. Monroe moved in and when Mr. Monroe began to park commercial vehicles there. Mr. Monroe has a snow plowing business. He testified that he had commercial vehicles parked on his property in 2013 in November. He said that he had done road work in 2013 to accommodate the vehicles that were working on his septic system, and that's one of the things that slowed the process down. He meets all the requirements of the Geese case. I know the Geese case well because I'm the one who litigated it from the Superior Court. We don't have the same issue of home occupation that was in the Geese case. There's no question that Mr. Monroe runs the home occupation out of his house. Mr. Monroe, under the Geese case, had an absolute right under the municipal code to park commercial vehicles on his property prior to 2013. The prior owner had an absolute right to allow Mr. Monroe to use the property to park commercial vehicles there in 2013. We don't want this case to be postponed. The evidence, I believe, is overwhelming. A preponderance of evidence in a civil case, or means, does the evidence convince you? Does 51% of the evidence convince you that Mr. Monroe parked commercial vehicles on the property during November and December 13? And all the evidence I heard tonight, and the evidence that was presented in the application process is overwhelming that Mr. Monroe parked his commercial vehicles on the property in November and December 2013. There was no rebuttal that was credible that he did not do so. So I'd ask you that you vote yes and allow Mr. Monroe's appeal to stand. Thank you.
Thank you, Mr. Clark. So with that, the matter rests with the board. And could I have a positive motion from the board member to grant the appeal? And then second, and then we will develop our findings after that. Yes, Ms. Eicher.
I'd like to attempt to make a motion, but not sure as to the form, so I may need some help. In case number 2015-0012, the applicant, Mr. Monroe, I move to grant the appeal in accordance with AMC 2103050B of an administrative decision denying legal non-conforming rights for an accessory use.
Yes, Ms. Eicher, and if you care to reference the recommendations that staff provided on page 7.
I would.
If you so choose in your motion.
Thanks for the suggestion. Yes, I move to grant the appeal pursuant to the department's recommendations 1 and 2 on page 7 of our packet. And I would be happy to speak to my findings after my motion is seconded.
Thank you. And could you speak to the condition to limit scope and scale at the bottom of page 7 as well, if that was part of your motion or not?
Oh, yeah. So in addition to 1 and 2, also adopting the department's recommendations following the condition to limit the scope and scale pursuant to that additional paragraph at the end of page 7 in our staff packet.
Thank you, Ms. Eicher. Mr. Hart, you've indicated you'd second the motion?
Yes, sir, a second.
Thank you. And Ms. Eicher, would you speak to your motion, please?
Yes. I can appreciate that we had a difficult case before us tonight, especially given the limited constraint of time at which we were looking to prove use which had occurred on the property prior to the change of code in January 1st, 2014. I noticed, or I take note, that the petitioner appealed on 7 distinct points. I find appeal points 1 through 6 not to be persuasive. And so instead, I'm going to focus on appeal point number 7. I do not find that, or I did not, for the reason why I didn't find appeal points 1 through 6 persuasive, I'll speak real briefly to that, is that it is the petitioner's burden of proof to prove to the staff in their application that they, with evidence that they have a basis for requesting the non-conforming use. And I don't believe that the application evidence was overwhelming. In fact, I do believe it was lacking. However, appeal point number 7, I think does have some merit in that I was persuaded by the testimony offered here today because it was enhanced by detail of, you know, when an employee left your employment, when someone handed off a key to access one of your buildings. You have a plethora of people that help you paint your house. That sounds lovely. But I was also persuaded that you had not only employees, but also neighbors testifying as to seeing commercial vehicles stored on the petitioner's property at some point prior to 2014. And I guess that, in my mind, is what we're really here to determine, is at any point prior to December 31st, 2013, was there commercial use of commercial vehicle on the petitioner's property. And it's for the testimony that was given today that I find that staff did not have the benefit of when they were making their determination, that I am persuaded that an appeal or granting the appeal is warranted. Without the benefit of that testimony, I don't believe I would be supporting any conclusion contrary to what staff has already provided today. Thanks.
Thank you, Ms. Eicher. Mr. Hart.
Thank you, Mr. Chair. I concur with Board Member Eicher, and I guess just for the record, it's really the large number of testimony, people that testified to him having property, commercial property on the commercial equipment on the property prior to 2013 ending. That makes it overwhelming for me. Nothing against the gentleman that testified that he didn't. It's just the large number compared to the lack of more than one stating that he didn't. I do intend to support the motion.
Thank you, Mr. Hart. Ms. Dole.
Thank you. I guess I'm a little troubled as I think about this with regard to Standard 7 and the evidence that we heard here today as to what I guess the phrase storage, because we heard a lot of testimony about the vehicles, about certain activities going on involving, you know, driveway work, maybe septic work, painting work, definitely we heard a lot about. And to me, bringing in vehicles, commercial vehicles for a job, and say the job takes a week and you leave the vehicles there for the week that the job takes, or you come in and out every day, is different than what we're being asked to look at, which involves storage of commercial vehicles for a different business activity. And so that's what I'm struggling with as I evaluate all the evidence. I acknowledge that there were a lot of folks who clearly recalled testified as to there being commercial vehicles there before the deadline, or before January 1st of 2014, but I'm not convinced that those vehicles were there in connection with other activities versus actually being stored there for business purposes, and to me, that would make a difference. I looked at the language on page 68 of the municipality's determination, where they cite the municipal code provisions prior to January 1, 2014, and that's they define accessory, and they refer to private storage, but it's customarily, and I don't want to get into the Geese decision. I understand Mr. Monroe has a business, and he has vehicles he uses in that business, but I'm not sure that using vehicles in conjunction with improvements to his new property would qualify. So that's what I guess I would appreciate anyone's thoughts on.
Thank you, Ms. Dole. Are there any other comments? Any comments from other board members? Yes, Mr. Ron.
Thank you, Mr. Chair. Board Member Dole, I was also similarly concerned over the connection between the activities over that time period and the need for the equipment, and trying to draw a conclusion between those two things. After the testimony had been provided, I still don't feel that I can make an accurate determination on that point. Carrying forward with that element of Appeal Point 7, I question whether or not I can make an accurate determination because of the singularity of the evidence that we have, and basing our decision solely on the testimony which is tied to the affidavits. That said, it is what we have to decide upon. I can't base my decision on the evidence that I wish existed, or perhaps think should exist in this case. Given that, I appreciate the comments by Board Member Hart and Eicher, and concur with those findings, and do intend to support the motion.
Thank you, Mr. Ron. Are there any other comments? Mr. Vig.
Thank you. I too wish that there had been other evidence to look at, and unfortunately that isn't what we have. And so we did have quite a number of people, including neighbors, testified to the fact that they saw commercial vehicles stored on the property prior to the January 1st date. So I think from that standpoint, I believe that you know, the evidence weighs in that direction. I do struggle though with it seems as though it's not being used as a place where a commercial vehicle is taken home at the end of the day and then taken out in the morning to go back to work. It's almost a transit yard, in essence, that people come and go and employees come and go, which I don't. I can appreciate causes problems for neighbors and other things like that. So I, on the one hand, believe that the evidence shows that commercial vehicles were stored there, but I'm struggling with whether it's a de facto home business, quite honestly.
Thank you, Mr. Vig. Are there any other comments? I do, and yes, Mr. Ron.
Thank you, Mr. Chair. Mr. Vig, very valid comments. I question, I guess, what recourse there may be to the public given that circumstance, as we don't directly address it in the department's recommendations, and would like to hear from staff on that topic. I guess enlighten me, if somebody could, is the public complaint process, at some point in the future, perhaps an avenue by which a member of the public could address this situation?
That was a question to staff, Mr. Ron.
Unless you'd like to answer it, Mr. Chair.
Ms. Inglis.
Through the chair, Mr. Ron, I think what you're asking is the impact of the commercial vehicles with the complaints of the road. Is that what's going on, and what the public could do in the future?
Ms. Inglis, what I find myself having to decide upon is the issue of storage of commercial equipment on the property. And I think Mr. Vig raised the point of the fine line between storage of equipment versus the use of that equipment in a transient type capacity. Not wanting to get into the business as a board of making that distinction between what is a business activity versus what is storage, are we in some way precluding future action on that point if we are to grant this appeal?
In the future, it will be difficult to enforce unless a business actually shows up there and changes the scope and scale of what the board has, if the board approves this. In the future, it will be hard to enforce if the board grants non-conforming rights for the use of the property for storage of the commercial vehicles, because in essence, then, he's permitted to have those commercial vehicles on the property, which means he could come and go with those vehicles as needed. And so it would be a very difficult issue to enforce if suddenly we have a bunch of vehicles coming back and forth all the time. That's why the condition of approval, if this board approves, tries to limit the scope and scale of the operation there, so that he can't increase the area or increase the number of vehicles on the property. So, for example, if the board says, we accept this condition, they can enforce if there's 4 or 5 or 6 vehicles on that property at any one time, and they would have to bring him back down to the scope and scale approved by the board. I hope that helps.
Thank you.
Thank you. Ms. Dole.
I'm not sure I can offer anything with regard to Mr. Vig's question, but I did want to, I guess, ask about the, I wasn't sure I followed 100% what with that positive motion, if we were proposing all of the language in that department recommendation. There's clearly the last paragraph that limits the use of the property for storage of commercial vehicles to the scope, scale, and locations shown in the hand drawing on the as-built in the area east of the detached garage and near the greenhouse, with no more than 3 commercial vehicles permitted to be stored there at any one time. And I think that's what Ms. Inglis was getting at in terms of ability to enforce. I thought number 1 in that department recommendation, it was maybe a little vague because it just refers to a greater area of land than was occupied at the effective date of the amendment of the regulations. So, but I'm comforted by that final paragraph, so I just would ask that when we vote on it, we understand what if we're voting on all of this whole thing, as all of the recommendations or conditions are a part of the motion.
Yes, and that was the motion, Ms. Dole.
Okay.
Mr. Vig.
Well, speaking to the scope and scale concept, a vehicle that's stored on the property that would exit and return would be 2 trips. In traffic lingo, that's what we call 2 trips. If you're storing 3 vehicles there, that's 6 trips for the 3 vehicles. And, you know, it could be possible to designate a certain number of trips that would be allowed by these commercial vehicles in and out of the property in the 24-hour period. But then in an attempt to keep it to a reasonable level of activity. And whether that's 2 trips in and out per vehicle for 12 in a day, I don't know what the number is. That would be one way to attempt it. Any other thoughts from other board members?
I guess I'll tell you, I intend to support the motion. I find that I concur with the findings of Ms. Eicher and Mr. Hart, and again, that Appeal Point, I actually find that Appeal Point 7 was met, and I do find actually Appeal Point 5 to be met. That, you know, the question was, were vehicles there before January 1st of 2014 or December 31st, 2015? And I think I've heard sufficient evidence this evening that that is what's occurred. We had 8 people plus testify to that effect, and that's what we have to go off this evening. The evidence that's been presented is what we have. So I intend to support that motion. Mr. Ron?
Thank you, Mr. Chair. Mr. Vig, your last comment is a natural progression of where I hope the discussion would go, and speaks to my concern over storage versus transiency or use. Dissecting the definition of storage, I don't know if we necessarily want to go there. What's storage versus what's parking versus what's some other type of use or occupation of physical space of this equipment on the property, and would be interested in perhaps exploring the recommendations you had. My concerns are over, of course, the department's support over that type of recommendation and enforcement therein.
So we have a motion. Was there a question of staff? I haven't heard a question to staff. So
can staff weigh in on a potential recommendation to document, perhaps limit would be the right word, the number of vehicle trips for the equipment that is stored as part of this legal nonconforming use, if in fact it's granted as such?
Ms. Inglis.
Through the chair, Mr. Ron, on page 1437 of the new code, down at the bottom is a definition of storage. But I also want to address the question of 1 and 2, item 1 and 2. That is actually out of the code, that they can't increase it or enlarge it. But as far as the trips, if the board wants to add an additional condition, the board can certainly do that. You would just put down at the bottom a new condition limiting the trips. It will be difficult to enforce because then it's going to require, if a neighbor complains about it, then it's going to require a code enforcement officer to, go up and view how many times vehicles, commercial vehicles are coming and going from the property. But it can be enforceable. It just is, it will be difficult to enforce. I'm sorry, did I sufficiently help you there? Or?
You did, thank you, Ms. Inglis. And if I could, for the record, read the definition of storage per the code that you referenced. And thank you to Board Member Eicher for actually having her Title 21 to show me. Page 14-37 of Title 21 dated December 3rd, 2013, definition of storage. Temporary or permanent containment, holding, leaving, stockpiling, or placement of products, goods, or materials, usually with the intention of retrieving them at a later time, semicolon, overnight parking of commercial vehicles. Thanks.
Ms. McConnell, did you have a statement? Or
Thank you, Mr. Chair, and I think we're jumping back and forth between two issues, and I apologize for that. I wanted to just add on to what Ms. Inglis said about numbers 1 and 2 on page 7 of your packet. As she stated, those are provisions of code which we provided to justify the board's ability to limit the scope and scale, so they are not intended to be conditions on the case. The only proposed condition is the very last paragraph, so if the board cared to clarify their motion, I think that would be helpful. Thank you.
Ms. Eicher, would you care to clarify your motion?
I would. I didn't mean to leave a hot mess there. So I guess my motion would be to, my proposed motion is to grant the appeal in accordance with AMC 2301-050B of an administrative decision denying legal nonconforming rights for an accessory use, with the additional department recommendation captured in that last paragraph on page 7, limiting the scope and scale of that use. Is that right, Ms. McConnell? Thank you.
And Mr. Hart, as the original seconder of the motion, do you concur with that? Do you make the second to that clarification? Thank you. So we have a motion and a second. Is there further discussion on the motion? Yes, Mr. Vague.
I would just state that with the definition, which Mr. Ron read, that defines storage as overnight of commercial vehicles, and I'm comfortable with the language as is.
Thank you, Mr. Vague. Are there any further comments? If not, please vote. That motion passes by a vote of 6-0. For the record, need to read every final decision of the board shall clearly state on its face it is a final decision with respect to all issues involved in the case, and that the parties have 30 days from the date of mailing or other distribution of the decision to file an appeal to the Superior Court. That concludes our cases this evening.
Mr. Chair?
Yes, Ms. McConnell.
Thank you. Now that you've concluded your business, I just wanted to let you know, you and members of the board, and you may know this already, but the mayor has appointed another member to the board. It's Mr. Ken Ayers, who's been sitting in the back. And I've lost track of exactly when the assembly is expected to confirm him, but I think he'll be seated for the next meeting. Is that correct? Yes, so he should be sworn in and seated for your next meeting. So I just wanted to let you know that. Thank you.
Thank you, Ms. McConnell. And I don't know if you caught it, but we moved our annual election of officers to the end. So is there anything that would preclude us from voting Mr. Ayers chair?
Well, you'd have to push it off to the next meeting then.
All right. So that brings us to our election of officers. We have to elect chair, vice chair, and parliamentarian. And
can we nominate our current officers by acclamation?
Well, I don't know. Mr. Hart I don't know if that was a vote or a comment he wanted to make, if he's stumping here with his speech.
That was actually to make a couple of comments. Honestly, this has been an incredible learning process, but honestly, I don't think I'm going to end up continuing on for another term. So I think I would end up having to deny or, sorry, it's late, whatever the proper term is, not accept.
Yeah. Mr. Vig, this has never been a stepping stone for me to do anything greater than this. So, I'd be happy to serve as chair, but I also think it's healthy to move things around as well. So I appreciate Mr. Hart's comment. If Ms. Eicher would like to step up into the chair seat, I'm totally happy with that as well.
Well, I'm honored to serve on the board and happy to be the parliamentarian. My current expected outages this year, perhaps with the arrival of my second child, aren't conducive to me taking on any greater role on the board right now. You might be able to convince me otherwise in the next couple years, but I would respectfully request to either remain parliamentarian or if someone else has a burning desire, they can take that spot as well.
Thank you. Mr. Hart?
I was just going to comment. It's pretty late. Maybe it would be best if we just postpone this till the next regularly scheduled meeting.
Oh, excuse me, I do not believe there are any cases for April, so I can email you, but I don't believe they are. But you're welcome to postpone them to May
So
if you want to.
Postpone till the May,
Up to you.
May hearing then.
Oh, we don't have one in April.
We won't get that. That's right. He's got 2 months. Or come up with excuses, one or the other. So, yeah, so could I have a motion to postpone till May? Mr. Hart, Mr. Vig, you've indicated you'd second that?
Yes.
Any opposition to that? None. Okay, we'll hold the elections in our May hearing. Are there any further comments from any of the board members? Thanks. I thought both cases were well thought out from all the board members. So. Does staff have any other comments?
No, thank you, Mr. Chair.
Okay. Could I have a motion to adjourn? Mr. Ron? Is that a statement?
Just a thank you to Mr. Ayers and look forward to working with the man that sat through that for 3 hours.
I know.
No kidding.
Move to adjourn.
All right. Have a second?
Second.
Any objection? We're adjourned.
Welcome.